Plum? So, all right, well, we're going to talk about two things today. Sovereignty is one of them. I don't know if you figured that out yet, but sovereignty is one of them. And the other thing is how to deal with the judge when you're actually in court. You're face-to-face with the judge. What do you do? Which do you want to hear first?
The judge.
The judge? All right, that's very important. Well, it's very simple. It actually is. When you go to court, at the time you go to court, you should have all your paperwork in. You say what you're going to say, you do what you're going to do, and when you're in front of the court, there is no reason to talk, okay, except for certain very key phrases. When you see, when there's a motion before the court, or whatever reason you're there, doesn't matter, arraignment, anything else, when you're in front of the court is not interested in what you have to contribute. The only reason you ever make any appearance in the court is so that the court can ask you questions, okay? When you file a motion, or when you file a petition, or when you file anything, you always, and I went over this in our last session, what is a motion? A motion has many different names, but when you file it, that is the actual trial, or that is the actual hearing. It's on paper. You say in your points and authorities whatever you've got to say. The other DVD of that last session goes into full detail on this. But that's where everything is said. When you actually get to the hearing, it's the option of the court. The court can choose not to let you say anything. And that's just fine, because you've said everything already. If there's some point of confusion, the court can ask you what you intended, or what you meant, or something like that, and then you can explain further. Anything else is off limits. Now, you've seen attorneys get up and they put in all sorts of new evidence right at the hearing. That's not allowed unless the court chooses to allow it, or unless you fail to object to it. Okay, so here's the simple rule of thumb. Anytime anything happens that you don't like, you object. That's it. 2 words. I object. That's all you say to the judge. I object. You say, I object. Okay? That's all you say when anything happens that you don't like. Now, the next thing that happens, give me a moment. I got a speech here. Now, I'll get to those questions. Okay. The very next thing that will happen, likely, not guaranteed, is that the judge will say, well, why do you object? And your answer should always be, it is not my wish that it be that way, or that this happen. Now, you understand, this is a centuries, in fact, more than centuries, it's a millennia-old tradition. Kings do not issue direct orders. Okay? Why? Because the king is all-powerful. Okay? So, in order to soften the relationship a little, instead of the king issuing a direct order, the king requests or wishes for something. The king's wish is the subject's command. Okay? The judge is your subject. So when you say, it is not my wish, you are issuing, just by those words, you are issuing a sovereign verbal command. Okay? Which cannot be ignored. So when you say to the judge, it's not my wish, that's all you have to say. The sovereign is not obligated to explain himself. Okay? It is not the place of the subjects to challenge the sovereign. Now the king, when you are in your sovereign capacity and you say that, the judge, if this is your very first session with the judge, he doesn't know this, or if he does know it, he doesn't realize this is what's happening. So he'll probably say, well, if that's the best you can do, you're overruled. Okay? And so then what you say, if you have the opportunity, if you don't have the opportunity, don't say it. But if you have the opportunity, you say, well, Your Honor, and it's okay to call him Your Honor, you know. It doesn't take anything away from your sovereignty. You just say, well, Your Honor, for the record, that is my wish. And then he says, okay, the record's noted. Okay?
The record is what?
Noted.
Okay.
N-O-T-E-D. So,
Should you object?
now, at that point, you've said everything you need to say. Just move on to the next item of business. Okay?
Should I take exception?
No.
No, because you have to about the last word. We're not hearing any of this on the tape, you guys. You're just
Yeah.
talking into space. You know,
Okay. Order in the court. Okay. Now, the thing is that when you have said that little train of phrases, you've done your job for the moment. Okay? Nothing more need be said. You've established your sovereign objection to whatever is going on. Then you move on to the next item of business. Same deal. Something else happens you don't like, I object. At some point, the judge may even say to you, yeah, I know, you object to everything. You say, thank you, Your Honor, that is true. Okay? And then you just move on. Now you don't have to say anything because the whole process is being objected to. Okay? Now, the judge is going to do whatever he's going to do. He's going to say whatever he's going to say. You don't have the guns. He does. Okay? And so you cannot take physical control of the judge. Okay? He has physical control of you whether you like it or not. Okay. So something changed there. We got some feedback. Okay. So what you do is you then leave the courtroom with whatever package you got. All right? Your next step is to go to your typewriter or your computer. By the way, if you're using a typewriter, I feel sorry for you. You know, word processor is the only way to go. And if you don't have a computer, get one. They're so cheap these days, you can get a used one for a couple $100. But what you do is you go to your word processor, and all those things that you objected to that went on, you simply issue an order reversing them. Okay? You do it on paper. Remember this, words are into the air and they float away. They mean nothing. All that has any meaning when you're in the court is the fact that you objected and it's noted for the record. And a lot of times they don't note it on the record, so you note it yourself in your own record. You keep a notepad right there at the table, and you note when you object something, you make it. And look, they can't push you too fast. You can take all the time you need to write that note. Okay? If he asks you a question, you say, I'll be right with you, Your Honor. I've got to make a note here. Okay? So don't let them push you into keeping bad notes. You just take whatever time you need to write your note. So let me review this again, since we had a lot of interruptions on the last one. I'll just go through it again. First step is, something happens you don't like, you object. Okay, that's number one. Number two, he says, why do you object? And you say, it is not my wish. And then he says, if that's the best you can do, then you're overruled. Okay? Then you say, well, for the record, that is my wish. And he says, okay, it's noted in the record. He may or may not say that. That is the entire procedure, okay, in the courtroom. When you leave the courtroom, that's when you issue those bombshell orders. That's when you cancel out everything he does. And I'll show you an actual example where we did this when we get into the sovereignty. All right, now, if, on the other hand, he respects your wish and says, well, all right, what do you want to do? Then you can say what you wish, whatever it is you do want. But whatever you do, don't argue with the judge. It gets you nowhere. Just a simple objection is good enough. Okay? He wants to shut you down, that's just fine. That's because he knows you objected to everything, and so forth. Now, if the record is not being properly kept, you know, you go back and you look at the docket and you see stuff that's not on there. All you have to do is file affidavits relating to that hearing, and you say this is what really happened. And ideally, you should have 2 affidavits, 2 different people, okay, behind you at your hearing who saw what went on, will each make up an affidavit of what they observed, and when you file those in, that makes the record too. Okay? And then you issue the orders. The orders are, whether they're ignored or not, they build the record. At some point, the weight of the record, the conceptual weight of the record, is what wins. That's all there is to handling the judge. Okay? Yes, sir.
What if there aren't 2 witnesses there present?
You're in trouble. Do the best you can. Yes, sir.
You said the judge is your subject.
That's right. Everybody's your subject if you're the plaintiff.
Okay. Then that brings in light Georgia. Chisholm versus Georgia says the people have no subject.
Well, he says the Chisholm versus Georgia says the people have no subject. Well, that's true. The people do not have any subjects. Okay? Hang on here. You don't have any subjects normally, but when you do get a relationship going, you know, you're the plaintiff, the defendant is always the subject of the plaintiff. Always. That's the relationship. You know, and if you are the defendant, you must convert yourself into a plaintiff. Okay, the way you convert yourself into a plaintiff is you file a counterclaim or you file a habeas corpus, either way. Those are the only 2 methods I know for converting yourself into a plaintiff. If you filed an original lawsuit, you're obviously the plaintiff. But you file a counterclaim. The counterclaim absolutely must be based on a challenge to jurisdiction. When you challenge the jurisdiction, everything must stop in the other court until they prove their jurisdiction to your court. Okay, they have to prove it to your court. They can't just say, oh, I'm wearing a robe. That's what one judge told me. He says, well, my robe is my jurisdiction. Okay. But, you know, the jurisdiction is the basis of your counterclaim, and that makes you the plaintiff. And now what do you have? You have plaintiff versus plaintiff instead of plaintiff versus defendant. Now you know, you're now the counter plaintiff, and you have the counter defendant. You've converted him temporarily into your subject. Depending on the outcome of that case, that may or may not be the death of the other case. Okay? Here.
Joe had asked you when people ask questions for you to restate the question before you answer it.
Do you want me to restate that question? Okay. Do you want me to restate that question? He says that when he wants me to restate the question when the question is asked or the point made. So I just did. Okay.
Okay, when you file that counterclaim, you do not ask for any monetary, correct?
When you file a counterclaim, you don't ask for monetary. That's not true. The whole idea of a counterclaim is that you've been injured by them taking jurisdiction when they shouldn't have. And you're challenging their jurisdiction. And if you've been injured, obviously you want the compensation for your injuries. You betcha.
Okay, if it's a criminal, you still have to file
Is that
a
on?
counterclaim civil.
Is that mic on?
I don't know.
If a counterclaim, look, we filed a counterclaim just recently. In the Los Angeles court. The Los Angeles court is so large, the left hand doesn't know what the right's doing. So I attempted to file it with the criminal courts. They wouldn't accept it. They said, this is civil. Well, technically they should have accepted it, but they're ignorant. So as long as your rights are not given up, go ahead and go along with their ignorance, okay? Doesn't hurt a thing as long as you're retaining your rights. So what we did, we said, okay, you don't want like that? We'll go over to civil. Went over to civil. I had the proper format for counterclaim. They didn't like that. You say, well, you got to be the plaintiff. I said, okay, scratch out this part. All right? So I scratched out the original criminal heading, which was state versus defendant, and the lower heading was the defendant, now a counter plaintiff, versus the counter defendant. That made the clerk happy. Okay? And then it said on the other side, on the right side, it said counterclaim. He didn't like that. I said, okay, scratch it out, and I hand wrote complaint. Now he was happy. Now, why is it that I was able to do this? Because titles and headings do not control. What controls is what's in the body. The clerk never looked in the body. He only looked at his customary headings, and he was too ignorant to know what the alternative procedures were, and I didn't want to hassle going up through the supervision and all this sort of stuff. When it, you know, I have now adopted pretty much a policy of just rolling along with them as long as the basics are not messed with. I don't worry about the details. As they say, don't sweat the small stuff, okay? And so when they filed it in, and one of the demurrers that we got back on it, by the way, the guy complained about how all this stuff was scratched out, and he's confused. He doesn't know who's defendant, counter defendant, whatever. Well, it's a personal problem attorneys have.
Okay. To follow up, though, the next step, if there are damages involved, should you make the damages high enough to go to the next level court so you're not in what was a muni court previously?
No, you should never do that. What you should do is claim the actual damages, whatever they are.
What?
Well, it's up to you.
Okay.
You know your injury. So
back to requiring 2 witnesses with you. If you can't get the 2 there on that date, can you request from the court a audio recording or a video recording of the proceeding?
I don't know what their policies are, but one of the things when I go to court, and if I don't have 2 witnesses with me, well, that's too bad. I mean, you do it the best what you can. You've got court reporters there typically. I understand that court reporters do not always properly report what was said. That happens. But they usually leave enough in so that you can hang them. So, but they do, you do the best you can. You know, you deal with reality. If you can't get people to back you up and be your witness, well, then that's how life is. But you make your effort. Remember this, once you're in charge, you got a lot of flexibility. Yes, sir.
Bill, I had a question. The judge we're dealing with in Oklahoma will not give us an oral hearing of any kind.
He doesn't have to.
So in lieu of being able to say these things in court, you just put it all in writing?
No, it isn't in lieu.
Oh.
It's what you do.
I see.
You always put it in writing.
Okay.
You see, if the judge, like as you said, the judge won't give you an oral hearing. He doesn't have to. That's purely the discretion of the court. Okay? When you file your papers, you need to look at the DVD, which you can get from Dennis Wilson, Whipple. You get it from Dennis Whipple, right here, who's handling this. Yeah, you can talk outside. So but Dennis Whipple has copies of the DVDs from before. Let him know that you want the other DVDs. You can get them. I don't know what he's selling them for. Now, the DVD you get for today is free. It comes with the package. But
If you attended last time, it's free too.
Oh, if you attended last time, it's free. You should have one. But I went into all the details about how hearings are in motions. But bottom line is that when you make a motion, you've got to have your affidavit of facts. You have to have your points and authorities, also called a brief, where you argue your case. And that's the actual hearing on paper. That's your brief is your hearing. Say what you got to say then. And it's purely the discretion of the court whether or not they have any questions to ask you. Once you have that hearing, you're not supposed to introduce anything unless the court asks you. Okay? So, in fact, if you file your papers and don't show up at the hearing, then you still made the appearance. Now, that's if you're on the defending side. They do a demurrer or something like that. Yes, sir.
Another question is, my understanding from what I've read so far of your work is that you talk about a court of record. Well, at this point, we know nothing's on the record. There are only things that are in the file.
No, you have a wrong conception of what a court of record is. Have you been to the website?
Yes.
Okay. I think. What is that? Somebody's phone? Okay. Anyway, time to turn off the cell phones. Anyhow, yeah, you need to go to the website and look up court of record, okay? Because the court of record, it has 5 requirements. Keeping a record is only one of them, okay? All right. 1215.org, 1215.org is the website. And, but you see, if you go to law notes and then you go to the foundation, and then you have down here court of record, okay? And that gives you the 5 definitions, which you can copy down as I'm talking. So the thing is that when you're in court on any kind of a hearing, that is not the time to present your case. It's too late to present your case at that point. You present your case on paper. And if the judge attempts to make any decision, you see, the judge in a court of record is not allowed to make any decisions. In a court of record, if you look at requirement number 2, the tribunal is independent of the magistrate. And if you look at requirement number 3, it's a proceeding according to the common law. There's no statutes in a court of record. Okay? I want to point out something interesting about California Constitution. It says in the Constitution, Article 6, Section 1, all the courts in California are courts of record. Now, that's not a direct quote, but that's the effect of it. All courts are courts of record. That means no statutes. It's got to be common law. That's why they have the arraignment process in a criminal proceeding. In arraignment, what they do is they ask you, do you accept the law but plead guilty, not guilty, or no contest? Okay? Well, if you accept the law, meaning the code, right? You're accused of violating section so and so and so and so. How do you plead? Well, if you choose any of those 3 pleadings, guilty, not guilty, or no contest, you've agreed to the code. You've agreed to proceeding outside the common law and inside the statutory law. You've jumped out of common law and into equity. So you need to object to the whole system. You say, you don't put any of those pleadings in. You say, I object to the whole thing. But anyway, so the tribunal is independent of the magistrate. Now, when you are the plaintiff, and that's very important, make sure you're the plaintiff. Okay, none of this stuff works if you're a defendant. So you absolutely must convert yourself into a plaintiff. It's easy to do. All you do is make a counterclaim. Okay? And the challenge is the jurisdiction. You can have other challenges. You can have other claims for injuries. You know, you got beat up in jail. Something. You know, those are claims you can make too. But the primary claim that you make is that the primary claim is that they exceeded their jurisdiction. Now, this is an important point. You all know about the Bill of Rights. You all know about how supposedly you have rights. The truth is you have no rights. Okay? You have a Constitution. The purpose of the Constitution is to keep the government surrounded with an invisible fence. So, you do not plead. Your pleadings are, when you're going against the government, your pleading is not that they violated your rights. Because there's nothing in there in the Constitution that says they can't violate your rights. Okay? So it's a wrong kind of claim. What you do is you claim that they exceeded their jurisdiction. If they don't have jurisdiction granted to them by the Constitution, then they can't take it. And so if they do take jurisdiction over you when they shouldn't, then you challenge that. You say, you guys exceeded your jurisdiction. And because you exceeded your jurisdiction, you caused an injury. And because you caused an injury, you owe compensation called damages. That's the sequence. Now you have a logical string of points here to make. So remember that. They exceeded the jurisdiction, number one. Number two, that resulted in an injury. Number three, they owe you damages for those injuries. If you lost any of your rights, that's the injury. You lost your liberty. That in itself is an injury, just the loss of your rights. They took your property. One of your rights, natural rights, not civil rights. Civil rights are privileges granted by the government. Natural rights you're born with. So if you lost a natural right, the right to speech, free speech, the right to free locomotion, the Bill of Rights lists them, okay, but you have more. If you lose any of those things, then what you do is you claim an injury. That is the injury itself, okay? You don't have to spill blood. Just the mere fact that you did not have were not able to exercise the right of voluntary locomotion. In other words, you can't walk anywhere you choose to walk. Okay? Your only limitation is that you cannot impose on the rights of someone else. Okay? So, bottom line is that you've got to be the plaintiff, and then you can make these claims, and your court supersedes their court on that basis. So are any questions on that? Okay.
Bill, if you're already in a court situation now, can you become the plaintiff through habeas corpus or by counterclaim if you're already in the case? Yeah,
if you're already in court, you've already got a hot case going, and you've gone down the line, there are some practical limitations to to making a counterclaim. Yeah, you should make a counterclaim before they've really had a chance to move down the line on it. I'd make a counterclaim the minute I know there's charges. Okay, but if you're downstream, the counterclaim becomes a little dubious. So you can always do a claim later anyway. But what you can always do is habeas corpus. Now, if you do a habeas corpus by motion, where you go into their court and you make a motion to them and you're begging the judge to do the right thing, 99.999% of all of those habeas corpuses get denied. Okay? But if you do a common law habeas corpus, a constitutionally based habeas corpus, which is the same thing, you do a habeas corpus, you are in your sovereign capacity. By what authority do they presume to rebel against the sovereignty of the country or the sovereignty of the state? Okay? If you are one of the people of the state, or one of the people of the country, of the United States in other words, well then they have no authority over you. The only way they can get authority over you, well, first of all, they can't. There's no way they can get authority over you. Okay? Just like the robber has no legal basis for taking your money. He may still do it, but he doesn't have a legal basis. So there is no legal basis, no way that they can take over you if you are sovereign. But what they can do is they can carry their information they have against you over to a grand jury. And then the grand jury produces an indictment. When an indictment is produced, that takes it out of the hands of the government. It is now into the hands of the people. That's the theory. Then The next step is a petite jury, or in other words, a jury of 12, and then the government can present its case, but it's still in the hands of the people, okay, the jury this time. That's the theory. Unfortunately, we no longer have people sitting on the jury. What we have is citizens of the United States sitting on the jury. And as you may recall, I've made a distinguishment between, I do distinguish between people and citizens. The people own the government, and the government owns the citizens. And that is, that's clarified here in people or citizen. Which one are you? Okay, when you go back to that page. Okay, so this all explains how the preamble works. Okay, so let me ask you this: is everybody clear on what to do before the judge? Any questions about that? Okay, I'm going to review it one more time. You go into court. Anything that happens you don't like, all you do is I object. Why do you object? It's not my wish. I don't wish it to be that way. I don't wish that you make that motion or that you grant that motion. If he says that's the best you can do, then you're overruled. Say, well, for the record, I do object. Don't argue, nothing. Move on to the next point. The judge will love you for it. Okay? That's the professional way, the proper way to handle it. You don't argue in court. You just simply make your very simple statement, I object. Then when you get back to your paperwork, back to your typewriter, your word processor, you issue the order reversing whatever he did. Okay? That's simple. Also, another thing is, when you're if you are being subject to their proceedings, their overruling, one of the things that you can do is you can demand to be released. Okay? Now, whether he does it or not is another question, but you want to be released from the jurisdiction. So that's the other thing you say in court, is that I demand that I be released from the jurisdiction. Now, they may ignore you, but it's important that you make the demand. Okay? Because you put the judge now in a position of, well, maybe he's breaking the law. He might know he's breaking the law by keeping you in jurisdiction. Okay? Okay, yes.
What if, from the get-go, they will not allow you to even speak?
If they won't allow you to speak, just make that clear in court. In other words, you speak. And then he shuts you down. He says, say one more word, you'll be in contempt of court. You've heard that somewhere before, haven't you? Sure. Say one more word, you'll be in contempt of court. Okay, Your Honor. That's right. But you say, because now it's clear, it's a railroad job, right? So, not a problem. Because when you leave that court, what are you going to do? You're going to put it on the record with your orders.
And you don't even say object, that one word?
Well, if he says say one more word,
then you're out. You say, okay.
Just remain silent. I mean, he issued the order. Look, he's got the guns. All right? Remember, don't allow yourself to get into the mindset of doing battle with these people. It's just the other way around, with that one exception that you do object. Otherwise, you be cooperative. Whatever he wants, okay, say it with a smile. Okay, Your Honor. No, you're not here to commit suicide. Okay, that's not your purpose. This should be a friendly thing. You want to survive this process, and there was I got to tell this little story, which is on here. It's somewhere on that website and CD. Everything that's on the website is on the CD. But on the website it says there's a story about this Buddhist monk, and it was, I think, a little after or during the Vietnam era. These Buddhist monks were throwing kerosene on themselves and setting themselves on fire, burning to death. And that was a tremendous embarrassment to the government. Now, the government had a standard way. I think it was it Thailand, I think, or one of those countries. Was it in Vietnam as well? But anyway, they had a standard way of dealing with problems, okay? All they did was whoever was causing the problem disappeared at midnight. Okay, that's all, no problem. But the Buddhist monks had a leader, and it was clear that this leader was responsible for this. He was the one who was encouraging the monks to do these suicide missions, okay? And he was a tremendous embarrassment and problem, and yet he never disappeared. The rule didn't carry out with him. He didn't disappear at midnight. So it was quite a wonderment to a lot of people why it was that he was able to be such an embarrassment to the government and still survive. Well, there's a very simple answer to that. It turned out that this guy was absolutely loved by everyone, even his enemies. They didn't want to hurt him. Okay? They didn't want to hurt him at all. I mean, yeah, he was a pain, but they liked him. Well, there's an important principle here. Make your enemy love you. Okay? You go into court, you treat these guys nice. You say, hi, how are you? You say hello to the clerks, you know. You talk about other friendly things, you know. Some people develop good friendships with the clerks, all right? They get to know you, and you'd be surprised how they file stuff in that otherwise they might not. And they'll, if you try to make it a friendly atmosphere. I know the moment you turn your back on them, they're going to stab you. Okay? I mean, that's a given. But you still be friendly with them, because it might turn out that the reason whoever it is giving you a problem is because he may be forced to carry out some sort of policy that's unwritten. At least it's not available to us. Okay? Yeah. So if he's doing that, he's going to resist carrying out those policies to their fullest if he likes you, whoever that person may be. So there's you see, in every system, whether it's a legal system, a computer system, you know, business system, in every system, there's a hidden informal system behind it. And there's a lot of communication that goes on. You know, you don't know. It might be that the clerk's husband is a good friend of one of the judges. It happens. Okay? I knew a guy who was a mechanic, and somebody made the mistake of suing him. Like, the person that sued him had no idea that this guy maintained all of the judges' BMWs and Mercedes. Okay? And he had informal conversations, and one of the judges said, don't worry about that guy. Okay? Show up in court, but don't say anything. Okay? The guy showed up in court, and the judge took care of it, looked very neutral. They had no idea that guy, whoever that plaintiff was, he had no idea that connection was there. I knew it because I was told. And but you see, the guy had a bogus case anyway. But what a difference it made if the judge knew you were a good guy and the other guys are bogus. You know, so there's more to law than just law. So I want you to understand this, is that you got to remember that in court, you've got to develop these social relationships. Maybe you don't feel very sociable going in there, but you still got to do it. It's very, very important. The world, you know, many decisions are made out on the golf course. Okay, not in the meetings. This is a fact of the business world, and believe me, the court system is part of the business world. You don't know who drinks with who down at the corner pub. Okay? So if you're one of the good guys and you're not somebody who's causing trouble, but instead just simply trying to assert your rights, and don't be afraid to yield a point sometimes. Lose the battle to win the war. That's okay too. You know, there was a Russian general that used that technique against the French when they were invading Russia. And his young lieutenants wanted to attack, but the strongest army in the world at that time was the French army. There's no way that Napoleon's army could be beaten. So what he did is he just burned all the land, all the land, all the crops everywhere. The only way that Napoleon could supply his troops was with long supply lines all the way back to France. And as they went farther and farther into Russia, the lines got longer, and more personnel had to be devoted to that, to the transport, instead of to the business of fighting. And then, of course, there was a little guerrilla warfare in there where they'd harass the troops at night so they didn't get a good rest. And the French troops actually made it up to the edge of Moscow. Okay? And then winter came. And they weren't equipped for that. And I'll tell you something, a lot of French soldiers stayed there, the ones that lived through the winter, stayed there, and many words in Russia now are French in origin. Okay? So, and it was all based on the idea of basically retreating, making it as tough for the enemy as possible, but retreating, and then the war was lost by Napoleon. Okay? Thought he was winning all those battles, but he actually lost the war. So, when you do your strategy, you got to look at that. All right, let's go into the subject of sovereignty. If you're satisfied with, everybody's satisfied with what to say in court, how to deal with the judge. Yes, sir.
Bill, can you run that counterclaim thing again?
Okay, you want me to re-explain the counterclaim?
Just briefly.
Okay.
Is it too late after the fact?
It basically, what I would do is I would do it anyway, because see, ignorance is everywhere. I mean, the attorneys don't know, the clerks don't know, the judges don't know the things that they should know. And so you really should have a counterclaim timely, but hey, put it in anyway. What are they going to do? Throw it out? Well, then they'll have to explain themselves if they throw it out. Okay? And basically you file your counterclaim. I think it's a little late to file your counterclaim after the judgment. Okay? But any time before then, you could try it. I think in reality you should have your counterclaim in within a month after their claim reaches you, after you're served. Okay? And their claim's supposed to stop until they prove their jurisdiction, prove that they had jurisdiction in your counterclaim. And one more thing, and that is that a counterclaim, the way you put it together, is identical to an original lawsuit. The only difference is that you've changed the name, counterclaim, and you're doing it on jurisdiction. The fact that you're challenging jurisdiction is what stops them. Okay.
What if they have a trial in absentia?
What if they have a trial in absentia? That should never occur. That should never occur. You should always show up for these things. Failure, you see, there's a rule in the court that basically says that if you fail to object, it means you agree. If you're not there to object, you're agreeing. That's simple. Okay, they have a trial in absentia, it's because they acquired jurisdiction. Once they get that in personam jurisdiction, they don't care if you show up or not. They say they care, but the truth is that the trial will go on. You're stuck. I would never not appear. I always appear on everything, okay? However, the conditions of my appearance are a little different. For example, if you have a counterclaim in, why am I there? Okay? The reason I'm there is because my court isn't open, right on top of their court. And if they do anything to extend their jurisdiction, you object, because they are misbehaving in front of your court. That's a contempt of court, by the way. And you can fine them for contempt of court. Okay? We did it once. The fine was too high, though, and he never paid it. We fined him $1. Okay? But he never really got a chance to pay it, because the presiding judge yanked him off, and they brought in a real top gun to deal with us who understood common law. So that's why we never enforced it. We would have enforced it if he had stayed. You have to understand what contempt of court is. Contempt of court only has two purposes. The first purpose is to preserve the dignity of the court, and the second purpose is to preserve the authority of the court. Okay? When that judge got removed, he was no longer a threat to either the dignity or the authority of the court. Therefore, the contempt issue became moot. No longer existed. That's why we didn't enforce it. Yes, sir.
Bill, in the case of, I guess I'll call it the IRS tax court, which is in Washington, D.C., how do you
the IRS,
prevent yourself from
the IRS tax court is your court. You are the moving party in an IRS tax court, from what I understand. Even though they say it's administrative, you're the plaintiff and they are the defense, right? You've made the charge, whatever it is, and then the IRS representatives come in and represent you. Well, here's an interesting thing, which I've never tested, but you got to remember the definition of a court. It's the person and suit of the sovereign. If you open up IRS court and you are the sovereign of the court and this is your suit, and then you label it a court of record, automatically it goes into common law, doesn't it? And if they don't object to that, it sticks. Okay? What's interesting is that in all the cases where we say, I'm one of the people and in this court of record complain of, in all those instances, never has any of the opposition ever objected to that or challenged it. They just read right over it. They don't understand the significance of that. And once they've accepted it, it's there. Because in the following paperwork, and in every paperwork, I always say the same thing, one way or another. I don't say it directly, I say it indirectly. I say, I am so-and-so, one of the people of whatever jurisdiction you're in, whether it's a state jurisdiction or the federal jurisdiction. And in this court of record, respond to, object to, whatever, okay? And they never challenge that. So that means they accept the definitions, right? We have a lawsuit going right now where we actually laid it out. We put all the definitions. What's a court of record? It's proceeding according to common law. We even put the case law that supports that. Every single attorney came back quoting code. There's no code in the common law. This is a court of record. There's no code in the court of record. And you see, as the sovereign, when you set up your court, what you do is you decree what the law is in this case, the law of the case. You all know that if you appeal a case and you failed to object to something, or you failed to bring in whatever laws, codes, and so forth, the Court of Appeals isn't going to fill in the blanks for you, right? They go on whatever you present. So, as a sovereign, you can decree what the law of the case is. Okay? Let me show you in our example. Let's go to the example here. Right there. Okay? In this example, if we go down to the, let's see, First Amendment action. First Amendment action exists because the original action wasn't any good. We tossed it out and replaced it with this one. Okay? But notice what it says. Paragraph 2, paragraph 2 would normally be paragraph 1 in a normal lawsuit or in a counterclaim. But this was the First Amendment action, so the first paragraph is devoted to explaining what the amendment was. Namely that the First Amendment action amends by entire substitution the action filed October 7th, 1998 in the above entitled court. There, how's that? Can everybody read it? Okay. So then we go down to paragraph 2. There we go. You can see the whole thing. Okay, so paragraph 2, which normally is the first paragraph, says, William Jones, hereinafter plaintiff, is one of the people of California, and in this court of record complains of and names the defendants. That's it. Okay, that establishes the forum, that establishes your sovereignty. And we'll get into that when we get into deep into sovereignty as to why the people are sovereign. And we go down here to further down. Here's the cause of actions, what was done. And now we have the law of the case. And the sovereign says, remember, if you're sovereign, you say what the law is. And I'll show you the case law that supports that. But take my word for it for the moment. The law of this case is further decreed. Okay, now the reason it's further decreed is because there had been some prior paperwork where the sovereign decreed the law. But here's where he decreed more laws in order to cover some problems that were popping up in the process. He says, if any claim, statement, fact, or portion in this action is held inapplicable or not valid, such decision does not affect the validity of any other portion of this action. That's now the law, because the sovereign so decreed it. The masculine gender includes the feminine and neuter. Okay? The present tense includes the past and future tenses, and the future the present, and the past the present. Now this is wording that you see all the time in the codes, right? This is where I got the wording from. So, but what I'm pointing out is that in the actual complaint or action, we are putting in what the law of this case is. And so it goes. Simplex dictum, that basically means we're just talking.
Bill, aren't you you had the California Vehicle Code, aren't you mixing codes with common law?
No. No. Good point. Excellent point. Let's go back here. California. Yeah, I will. Okay. The question is, we're using California code here. Aren't we using it? Aren't we using code? We thought this was a common law court. Well, we are proceeding according to the common law. We're just proceeding. That's what a court of record does. It proceeds according to the common law. But the purpose of the court is to right the wrongs. Okay? Now, this whole case comes from the sovereign. The sovereign is the plaintiff. He's suing. The definition of a court is a person and suit of the sovereign. So what the sovereign did was decree that this is the law. So the authority comes from the sovereign. The words come from the Vehicle Code. That's why it appears we're using the code. It certainly fools the attorneys. So the attorneys might quote another contradictory code somehow, but it doesn't mean anything in this court because he's not authorized to decree what the law is. Only the sovereign decrees the law. The defendant does not decree the law either. Okay? So that's an example in a lawsuit where we decree what the law is. Okay? Okay. Back to this. All right. Let's get into the logical chain of points.
Bill, one more
Yes.
question.
Uh-huh.
If we choose to use the habeas corpus, do you have an example of that?
Not today, no.
Okay.
But the principles are all there because there's in terms of form, basically, in practical terms, the only difference between a habeas corpus and a counterclaim and a regular claim, the only difference is you're not asking for damages. You're not claiming an injury. That's very important. Do not claim an injury in a habeas corpus. All court proceedings basically amount to a search for the injured party. That's basically what every court proceeding is. We're looking, somebody's making a claim, but we have to say, well, who is injured? Okay? In a habeas corpus proceeding, you're not claiming an injury. What you're doing is you're looking for the injured party, the corpus delicti. Okay? That's what you're looking for. If you say you are the injured party in a habeas corpus, you have now granted them jurisdiction. So you do not admit to any injury. You may be standing in front of the judge with a pool of blood around you. Okay? And you are not injured. You are merely undergoing a reasonable inquisition in the search for the injured party. However, if they fail to locate the injured party, you then may become the injured party because it was obviously an unjustified search. And the techniques used were unjustified. But you're never the injured party in a habeas corpus. You know, habeas corpus has been used a number of different ways. It hasn't always been used the way we think of it being used. For example, habeas corpus has been used to go out and pick up somebody. We're looking for the injured party. Produce the body, right? Well, he's not in jail. He's out on the street. Go get him. So habeas corpus was for, I think it was about 100 years. It was used in that manner. It rose up to popularity among the prosecutors and sheriffs, and then it lost popularity because it was abused, of course. But it was used that way. So habeas corpus can be a dangerous thing too. But basically, don't talk about your injuries. Don't talk about whatever's done to you. What you talk about is their lack of jurisdiction and where's the authority. And don't give them any hints either. Don't tell them they didn't produce an injured party. Let them figure out they have to produce it. Later on, you can make a ruling saying that they didn't produce the injured party. Yes?
Where would you file the habeas corpus?
Habeas corpus, that interesting thing about a habeas corpus is that you can file it anywhere, in any court. And you can file multiple habeas corpuses. We did one for, you may know Al Thompson. Okay? A habeas corpus was filed in the, as I understand it, in the United States District Court, which was the court that was chastening. It was filed in the appellate court. It was filed in the Supreme Court. It was filed in the State Superior Court, the State Appellate Court, and the State Supreme Court. There were 6 of them filed. I think it cost something like $50, $60 for postage. And hang on. So then that got him some results. That shook the system. But anyway, yeah, okay, you had another question, if you're right with you.
Yeah, during Lincoln's time in the Civil War, I understand he didn't allow habeas corpus.
Well, look, once Congress gives authority to the president to conduct a war, then he has the discretion to conduct it any way he wants. He may have to answer later for what he did. So everybody, from the legal literature that I've read, everybody agreed that what Lincoln did was illegal when he withheld habeas corpus from everybody. But he did do it. I mean, that's power. Well, I mean, you know, when the robber has a gun in your face and says, "Give me your money," what do you do?
Give him the money.
That's right. So you see, you can't, you know, Lincoln had the physical power, so who's to stop him? They're all telling him it's wrong, but he did it anyway. And that isn't the first time, because who was it? I think it was Jefferson, and maybe it was also Lincoln. One of those two, I think, actually arrested a congressman because the congressman was politically opposed to him. Okay? Wrong? Illegal? Yeah, but who stopped him? Yes?
Now, are all these habeas, are they the same, or do you wait till one gets rejected and then file?
No, it was all hit at the same time.
Hit at the same time.
Yeah. Okay? Now, in the Supreme Court, when you do a habeas corpus in the Supreme Court, they want to know, why didn't you go to the appellate court first, a lower court? So they want that explanation. But other than that, they're the same. Yes, you had a question over here. Somebody did. Okay. All right. So shall we get into sovereignty then? Now, is everybody satisfied? Last call for what to say in court. Okay. Then we'll get into the sovereignty. All right. There's a chain of logic that you have to pay attention to when we're talking sovereignty. Okay? Now, I want to emphasize a couple of things here. Wise men are instructed by reason. Okay? Everybody read this okay? That's large enough, right? Wise men are instructed by reason, men of less understanding by experience, the most ignorant by necessity, and the beast by nature. That was by Cicero in his letter to Atticus. And in order to make this stuff work, you absolutely must be instructed by reason. It's difficult to find cases to support your sovereign point of view. So you have to take what you see, put two and two together, and on your own figure out it's four. Okay? The very first order I ever issued in a case was not my case. The sovereign of the court, the sovereign was in jail. He had moved for habeas corpus in the Superior Court. The Superior Court judges just overruled him, didn't recognize his habeas corpus, which was handwritten because he was in jail. He was being held in jail by the municipal court. So what he did was, by sovereign authority, since he had already created his court with the habeas corpus, Superior Court, he appointed me as a special master in his court. Now, a special master is basically, in this sense, is a judge without the pay. Okay? He gave me blanket authority to do a number of tasks, and so I was going to start performing them. And I started researching the case and so forth, but I filed a copy of the special master appointment. Now, understand that we had no precedent, but according to our research, if he's the sovereign of the court, if it's his court, he can appoint anybody to staff his court, right? You know, if necessary, he could appoint a court jester. Okay? In this case, I'm my own court jester. But that's why I wear the hat. But you see, he appointed me as a special master, and I had the authority to investigate, to take testimony, and so on. So I started working on the case. Well, while I was working on the case, there was a jailhouse rumor that he was going, his case was going to come up for some sort of hearing the following Monday. So I quick did some research as to what we could do there, and again, no precedent. All I knew was that I was a special master of the Superior Court, and I was entitled to conduct hearings. So I went down to the municipal court, and I met with the judge in chambers before he started his court sessions, and I said to him, I understand that you have this case. You know, I requested, and I got a hearing, and I was dressed looking like an attorney, by the way. You know, pinstripe suit, no beard, okay, proper tie, vest. I actually had a vest.
No crown.
No crown, right. Like I was a subject, right? And so I went into chambers, explained to him that I'd been appointed a special master in the Superior Court. I understood that this case was coming up for hearing, and I was here to observe the proceedings. Well, anyway, it got to be a little more fun after that, because the prosecutor came in and started talking about the case ex parte. He didn't know I was there in my capacity. He thought he took one glance. He said, "Oh, fellow attorney, you know." So he's talking to the judge. But he started talking about this case, which is absolutely illegal, of course, for him to do. You know, the judge was no dummy. He said, wait a minute. He says, this is getting too complicated. We need to go on the record. He cut it off, okay? But of course, if we had chosen, we could have prosecuted the prosecutor for that. Anyhow, we didn't, but we went out into the courtroom. When he called the case, I stood up, and on my left was the prosecutor. On my right was the public defender that had been appointed that he did not want, that the defendant did not want. And so when it came my turn to speak, and I'll tell you in retrospect, I was very lucky. I had a very intelligent judge up there. He was far better educated than most municipal court judges. But at the time, I didn't know that. And so he said to me, he says, what do you want me to do? Well, I'm a special master in the court. I cannot instruct him what I want him to do as an individual. So I spoke regal language. Now, you understand, in regal language, the king never orders anything, right? He only wishes for things. In regal language, you speak in the third person. The king never says I. He himself refers to the king when he means himself. Okay? So and since I was on borrowed authority, because I was not in sovereign capacity, I was in a master of the court capacity. So I said to him, I am William Thornton, and I've been appointed a special master in the Superior Court of the State of California, and I am here to observe the proceedings in this municipal court case, and I'm here and now declaring the Superior Court of the State of California open and in session. And so then we started talking back and forth a little bit, and I said that it appeared that there were some common law rights that were at stake here, and the judge immediately informed me that, well, the common law had no standing in this court. And so I informed him that I said, yes, I said, you're absolutely right, Your Honor. I agree that it has no standing. However, in Miranda versus Arizona, the court said that where substantive rights are at stake, there shall not be any rules that would abrogate them. Okay? So he agreed, that's right. He knew the Miranda case, okay? Everybody's heard that read your rights case. Well, that's a nice part of the case, but the real thing about the case is that they can't make any rules either for or against your rights. Rights stand on their own. So he acknowledged that. We're dealing with substantive rights. So we paused for a moment. This is a little war story here. We paused for a moment, collecting our thoughts, I guess, and the prosecutor stood up, and she said, Your Honor, who is this man? I don't know who he is. I don't know what he's doing here. The judge just stared her down. He didn't say anything. She finally sat down, frustrated. And then he turned back to me, and he started speaking, and what he said had absolutely nothing to do with what she had to say. It was the greatest act of discourtesy I've ever seen a judge commit against a prosecutor. You know, I mean, normally these folks are very close. Well, my knees were shaking up until that point, and then I realized I had something here. Here I am, a third-party invader, and he's giving me full attention. Okay? Something's going on. I must have figured some of my theory was right here. So I proceeded. And he said, so he asked me, what is it that you want me to do? And I said, well, it is the wish of the Superior Court that the municipal court release jurisdiction of this matter to the Superior Court until such time as the issues in the Superior Court are settled. And he said, I will do that if you will give me the order in writing. Now I went personal in my conversation. Back to me. I said, well, I came prepared with half an order, Your Honor. I said, I didn't know how things would go, but if you will recess the case, I will complete the order and be ready when you recall the case. And he said, okay, and so that's what he did. He recessed it. And then I rushed all over, you know, I wrote it out real fast, and then I rushed all over finding a copy machine, getting copies made, you know, and came back. So when later on in the day, when he called the case, I then gave it to the marshal. He passed it up to the judge. The judge read it into the record, and then he ordered the order to be filed into the case. And then that was the end of that session that day. Okay? So that's how we did it. That was sovereignty in action. But the thing I got to understand is that we arrived at this purely because of a reasoning process. Okay? Purely because of that. We said if A is true and B is true, it must follow we got the authority. Now, not everybody likes to think. And this is tough. How many times have you heard somebody say, do you have an example of this? Have you ever, can you show me any case law? You ever heard anybody say, you don't have anything unless you got a case to support it? I've heard that. Okay? Not true. Not true. There are priorities. The highest law is the common law. Okay? The Constitution is under the common law. The Constitution recognizes the common law, too. And you can see in the 7th Amendment, when you have a case at law, no decision by a jury is reviewable in any court. That's what it says right in the Constitution, in the 7th Amendment, other than by the rules of the common law. And what do the rules of the common law say? Well, basically what it says is that if a jury makes a decision, the only way you can beat that is with another jury. But the Supreme Court has no authority to touch it. Now, if you're wondering why judges cancel out certain juries' decisions, it's because those were not real juries. Those were advisory juries. That's another situation. Yes, sir.
Bill, a question. Can legal maxims which are based upon the common law be used?
If you decree them so, sure. See, you have to decree it. Make it the law of the case, and you betcha. Yeah. Right. As a matter of fact, anything. I have a law, some of you have heard about this already. I have a law that is my own creation. And that is that nobody is allowed to wear pink shoes in my presence. And I take this very seriously because there's a death penalty associated with the violation of that law. Okay? Now, I have to acknowledge, because of the impact of reality, I have to acknowledge that it would be very difficult if the defense were to invoke a jury, it would be difficult for me to get a jury to accept that law. Okay? But they don't understand my background. Okay? I think it's a reasonable law, but I acknowledge that most jurors would not find it reasonable. So what most jurors would do, because remember, the job of a juror is twofold. They judge the facts, right? They also judge the law. And if they don't like the law, they can throw it out. Jury nullification, right? So the probability is, I have yet to achieve a single conviction, by the way. But, and that may have something to do with it. But now you turn it around. Let's say I have another law, which is that if basically the law operates this way. If I'm walking down the street, totally minding my own business, and a total stranger comes from behind me and strikes me and injures me, I think that person should pay for all the medical bills, and that person should maybe go to jail for 30 days, okay, at least. And if I bring charges that way, it could be in civil, he can be put in civil jail, okay, not necessarily criminal, but if I bring charges, I suspect that most jurors would roll with that one, okay. But the law comes from the sovereign. You decree it. That makes it the law of the case. If you don't decree it, you don't have the law. Now, if you fail to decree it, then what happens is that maybe the judge might invoke it. I don't know. Or whatever. They work it out. But that's for people who don't understand they're in charge. But if you're in charge, you must decree what the law is before you can run the rest of your case. All right, but where do you find this law? Well, you make it up. But I try to make my law, with the exception of the pink shoe law, I try to make my laws pretty well meet the existing pattern of statutory law. I borrow their wording, but it's my authority that makes it a go. Okay? That's why it said, you saw there, the law of this case is decreed as follows. and my signature is at the bottom of the paper. Okay? So that's where the law comes from. But you have to be instructed by reason. If you want an example for everything you do, believe me, this is not going to work for you. All right? It won't work. You've got to be able to reason the process out. If A is so, B is so, then C must be so. And if you're not good at that, then don't try this stuff, because it isn't going to work for you. All right? This is a thinking person's system. This is not a fill-in-the-blank system. Not at this point. I'm working on it, okay? Give me a few months. I may have something that will help in that department. But right now, it's a thinking person's system. Okay, understand this. Running quickly through it. Language and dictionaries. In America, we speak 3 languages. Okay? Street English is one of them. Second one is formal English that you learned in school. And this is the language that most attorneys use. And then there's the language of the court. That is the third English language, which is not taught. Okay? If you want to know what a word means, go to the set of books called Words and Phrases. It's in most law libraries have it. Or if you don't have that, if you have access to the internet, and you should have access to the internet if you're going to play the game, it's one of the tools of war. Okay? This is civil. Going to court basically is civilized warfare. Okay? And even though you're friendly to the opposition, they're not your friend, you're not their friend. Okay? But if you're on the internet, you can search cases for certain words, because sometimes they argue over those words. And you'll find out what they really mean. But you can go to the set of books called Words and Phrases. You can also go to case law and look up words under case law. And also there's American jurisprudence. There's one, Roman numeral 1, 2, and 3. Okay, there's 3 sets now, I think. It's up to Am-Jur third. You can look up words there, because the legal meaning of a word may be different from the popular meaning of a word. The most obvious example is the word democracy. Everybody I've talked to, when they say the word democracy using their normal day-to-day formal English, they really mean a republic. You know, you ask them what a democracy, and they describe it to you. It pretty much is a republic. I made a talk recently before another group, a political group actually, and they had big signs all over. It said democracy on it. You know, I had big ones. They're pushing big on democracy. It wasn't the Democratic Party either, and so I pointed out to them this fact that we speak 3 languages, and I said, I know what you mean, but don't use that word when you go to court. Because it has an entirely different meaning in court. And then I explained it to them, and I got them all converted over. They understood that it was fine when they're in the popular, it's fine for the posters, but don't ever bring that into court, because a democracy and a republic are 2 different things. So understand that there's a different language spoken in the courtroom. The way I started, and I'm surprised every day at things I thought I knew what they meant. Okay? But when I first realized that the legal language was a separate language, even though it was still called English, and I started studying as such, what I did was I started with the Constitution. And it said, we the people, etc. And I looked up we, and I looked up thee, and I looked up people. I just proceeded. It was, to me, I pretended it was a brand new language, and I didn't know what the word meant. And I went to the legal dictionaries and to the Words and Phrases set of books and so forth to find out what these words mean. It's pretty shocking sometimes, you know. Resident. Okay, there's another one that you're familiar with. Okay, resident in everyday language, yeah, it means, you know, you live here. But if you're speaking legal language, the proper word is domicile. Okay? If you're domiciled here, you don't have to explain yourself. If you're a resident, that means you came from outside the jurisdiction. and you're here for a specific purpose, and when you accomplish it, you'll leave, go home. Okay, you'll leave the jurisdiction. So if you're a resident of California, you came from outside of California. I might ask you, are you a citizen of the United States? If you say yes, well then obviously District of Columbia is your home. Okay, if you're a resident of California. That's why it is. You never see the word resident in, you never see the word domicile in your legal papers. Driver's license application, right? Are you a resident of California? Well, they can't require driver's license of people who are domiciled. But if you're a resident, you cross over the border, you're a foreigner. Yeah, we got a question generating back here.
Okay. So if you fail to leave the jurisdiction, then what happens?
Well, I don't have that problem. I'm domiciled.
I mean, I'm talking about anyone who wouldn't.
Well, why would you claim you're a resident if you know you can be
Well, I'm
domiciled?
talking about the rest of the people, or the rest of the citizens, let's put it that way. Anybody else? I'm trying to get an alternate answer.
Well, I'm telling you, don't be a citizen. don't be resident. Okay? Otherwise, you have to explain yourself. I don't explain myself. I'm one of the people. Okay? Don't let it get past the gate. Cut them off at the pass. If that question comes up, stay on point. Don't suddenly get off point on that, okay? Does that make sense?
Yeah, but there's a whole bunch of other so-called people out there, and I just wanted to know what other thinking would be.
Well, look, the answer is very simple. If you screw up, you get hurt, okay? Even if you're ignorant. Those other people out there who wish to call themselves citizens and residents, they're not here being educated on the point. Okay? Can't deal with those people. Yes, sir.
It's my understanding that if you say the words United States citizen, that's different than saying citizen of the United States.
Well, the question is that is there a difference between citizen of the United States and United States citizen? And first of all, the United States citizen is a phrase that I have not found in the legal literature. But what I have found in the Constitution, it defines what a citizen of the United States is. And so that's the language I use. I stay with constitutional language, and I don't get off point. United States citizen or citizen of the United States doesn't apply because in my cases that I'm involved in, I'm always one of the people of the United States or one of the people of California. Don't get off point. Remember this. Our great leader, Abraham Lincoln, was an attorney. And he advised us that if you don't want to argue a point, don't bring it up. Okay. Yes, sir.
In the preamble, it says the word people,
yes,
citizen, is synonymous.
It doesn't say that in the preamble.
I just read it the other day.
Well, not in the preamble.
And it was a pre-1933...
I'm sorry. If you're talking a case, that's one thing. If you're talking about the preamble of the Constitution, there is no word citizen in the Constitution in the preamble.
I'll look it up again.
You look it up.
Okay.
Bill?
Yes.
2 days ago, I was watching on CNN a discussion in a constitutional law and foreign law of Justice Scalia and Breyer. Mm-hmm. And Scalia was saying that when he looks to the Constitution and the language of the Constitution, he always goes back to Britain and the laws and the language of Britain. Because when the founders were writing the Constitution, they weren't interpreting it, they were writing it, they were using the language of that day and the understanding of the language of that day. And that is what the justices are supposed to be doing in their courts.
All right,
in the courts.
If you go on the internet, you can buy a computerized version of Webster's 1828 dictionary. And I use that frequently to get those original meanings.
I have one in the car if you want to use it.
Okay, it's good to know about. We don't need it, but yeah, it's good to know about. But yes, that is correct. The in fact, let's just take a look here.
Bill?
Yes.
I'm from Oregon, so
Sure.
then how does that work with leaving after you're if you're a resident, if you're a non-resident?
I don't see any difference. You know, if you wish to bring up the point that you're from Oregon, well, now you got something to argue about. I wouldn't bring it up in the first place if I were local to California.
If you're domiciled in California.
He's not, he's domiciled in
Well, no.
You can be domiciled in most states.
Now there you see, you can be you can only have one domicile, but you can have as many residences as you want. Okay? In fact, that issue came up during one of the elections. Somebody was running for presidential election, and they said, hey, he's not resident in some place. Oh, yeah, he had multiple residences, and he was resident. So, yeah, you don't, you're running out of wire.
Yeah.
Don't pull.
Over his head.
All right, so, now, look, don't get distracted like I'm being distracted. All right? Don't get distracted. You're bringing up bogus issues. Don't, you know, if you want to argue the point, sure, put it in your papers. But I find if I leave a lot of stuff out, it saves a lot of discussion. Okay? So don't say you're a citizen of Oregon or you're from Oregon and they're treating you unfairly because you're an outsider. Okay? You say you belong here. Your domicile is right here. That your domicile does not affect your residence. Okay? All right. Yes, sir.
If I claim to be of,
Microphone.
it's not.
It works.
Is it? If I claim to be of the people, can they use my past contracts as evidence to prove otherwise? In other words, they might try to claim that I am a citizen.
All right. If they wish to bring in a contract, all you do is you say, all right, show me the contract. All right? So let's say they do. I've never had them produce a contract, but let's say they do. They produce a contract. You read the terms of the contract. Where's your signature? Well, they say it's right here. You got a driver's license or you got a Social Security card or so forth. Well, and you're saying that that's the terms of the contract? They say, yeah. Well, I didn't know that. You knew that at the time I signed the contract? You didn't disclose it to me? You knew that I would object, and you kept that hidden?
Void from the beginning.
Void from ab initio, right. Void contract, okay? Standard contract law. So that's why I'm not concerned about contracts. But there's another important point. You can be a citizen for some purposes and not a citizen for other purposes. Okay? And the option is purely yours. The only time they have general jurisdiction is when the person generally is a citizen. Okay? All right. So, anyway, language is important, so be sure that you use the right language and get to know the legal language as a separate language. Okay? So that instead of being bilingual, you should now be trilingual. Now, you're all bilingual, I know, because you know slang and you know formal English. Those are two languages right there. Street English and formal English. Well, now you have to learn the third language, which is court English. Okay. Now, let's get into people or citizen. Which one are you? Because I'm going to beat this subject to death. The preamble, since you brought it up, we're going to talk about it. Let's go right down to it. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Where does the word citizen appear?
I'll send it to you.
It isn't there.
No, it's not there.
Well, that's what counts.
But it's in the Constitution, the book. It's in the book.
So what?
I got it.
I don't care. It's right here. It's not in the preamble. Okay?
I'll send it to you.
Now, look at the... Send it. I got it right there. There's the quote. Look. let me tell you something. All right, here's the hole in my logic in arguing with you. No, it's fair, okay? The hole in my argument is this, that it could be that the original handwritten Constitution that everybody agreed upon in that big meeting they had in Boston, I think it was. Was it Boston? No, or Philadelphia. Philadelphia. Yeah, it's Philadelphia. Okay, that big meeting that they had where Benjamin Franklin came out and told the lady it was a republic if you can keep it. That could have the word citizen in it, so far as I know. I've never seen the original. But here's what I do know. I do know that what you see right now is the present-day scam. Okay? I'm giving full faith and credit that maybe the original Constitution, the real Constitution, is different. But this is what's advertised. This is what's promoted. If I walk into court and I say, I'm using this, do you think they're going to say, oh no, here's the original? You think they'll do that? No. Do you think they're going to blow their whole scam just to win this case? No. So it's important to understand, again, back to what is law. Law is more than just what you can prove in print. Law takes in other factors, and one of the factors it takes into account is policy. What do the powers that be want? Well, they are, as far as I know, promoting this. I accept it as true. Okay? I run with it. I don't bring in other factors because I am a true believer in the advice of Abraham Lincoln. I'm not going to bring up a point that I don't want to argue. So I'm not going to argue as part of my lawsuit that the original Constitution is wrong and here's what it really says. Okay? I'll roll with the scam as long as it works my way. And this does work my way because we, the people of the United States, now it doesn't say what people are, it only says that they exist. We, the people. And where do we come from? We come from the United States, or in other words, the States United. Okay? And we have a purpose in order to form a more perfect union and so forth. Got a laundry list of tasks to be done. Okay? And we say that we do ordain and establish this Constitution for the United States of America.
That's a different entity.
That's a different entity. The United States of America is a different entity from the United States. And we're the people from the United States. We took matters into our own hands, and we created the United States of America. And we've got this Constitution for them. And notice this. It says, here's the specific words. We do ordain and establish. Ordain, the word ordain means our sovereign decree. Okay? Ordain means make law. Ordain means authorize. Okay? Lots of different meanings depending on context. But the authority came from the people. The sovereign people created this. Now, I can't tell you what people are, but I know the relationship between whatever those people are and the government, the United States of America. So we ordain and establish this Constitution for whom? Not for you, not for me. It was for the United States of America. So there you have the very essence of sovereignty. See, I know I've had some people say, well, I'm not sovereign, God is sovereign. Well, the word sovereign is actually one of those relative words. Sovereign relative to what? So, I'm not sovereign relative to God, but I definitely am sovereign relative to the United States of America, if I'm one of the people. Time out for a tape change.
Okay, we're rolling. Forget it. It's not a break yet, you guys.
Okay, does anybody want a break? Is it time? It's 11:45. Do you need a little break of some kind? Why don't we take a 5-minute break, all right?
Before we break,
yes?
Could we decide on maybe setting up a mic in the aisle there and letting people...
have a mic stand, so if we'll put it on the table, that'd be fine.
Because this is really disrupting, passing the mic around.
We don't have a mic stand. He just told you.
We can put it on the table.
Okay, so let's take an exactly 5-minute break, and then we can roll on. Okay, it is now exactly 12 o'clock by my watch. So at 12, we'll have lunch at 1. Okay, we're on the air. Okay, so going back to the subject of sovereignty, the question is people are citizen, which one are you? And this is kind of important. If I can find it here again. There we go. People are citizen, which one are you? So we have the preamble. The preamble basically is what is presented to us. You know, we're not in the position to know everything. We're not in a position to know what it is, you know, is true and what's not true. The best we can do is go to the law library, do our research, and of course use our brains to whatever extent we can in order to get at whatever the truth is. But there are forces in the world much bigger than any one of us. We have to acknowledge that. So in this case, one of the grand forces of the world has presented to me, partly in the school system, partly in the law libraries, that this is the preamble to the Constitution. So whether or not it really is, whether or not it came from an engrossed copy or not, because I've been told that things are different, this is what's being advertised. So I take it on the surface. And when I go to court, I know that the man behind the bench is looking at the same thing that I'm looking at pretty much. And if I present it, if I say that I'm one of the people of the United States or one of the people of Arkansas or whatever jurisdiction we're talking about, I know that they're basically going to accept it. And if they don't accept it, well, then it's time for the truth to come out, right? We'll look at his truth as compared to my truth. We'll see which one is the true one. And of course, that if it turns out it is different, you can bet there's going to be a big argument about it, right? Because this is what I was told. But you resolve it. Well, my theory is that these guys are not going to blow their scam just to win this one case. Okay? And so if I happen to catch them in a little mistake in how they presented themselves, well, they'll live with that. You know, no one of us is a big factor to their system, so they'll let us go on that point. Well, if they don't let us go on that point and they try to pull rank because of some secret they had, that immediately invalidates them, because now you can say, well, hey, you knew that all along? That wasn't part of my contract with you, if you're saying I had a contract. Okay? And so under normal contract law, it's invalidated, right? Is everybody clear on that? So anyway, so I fly on that principle. We, the people, ordain and establish this Constitution for you guys, meaning the government, the United States of America. Well, there is absolutely nothing in the words ordain and the words establish that says that the people gave up their original sovereignty. See, when we broke away from England, we rejected the king. Also, the king rejected us. He issued an order canceling all the charters. So there we were, cut loose. And, of course, there was a physical fight over it, and a little war, but we won. And so all I know is that when we broke away from England, there was no system. There were no precedents anymore. So the people were on their own. The people were 100% self-governing. So then there was a few people who were organized, and they called themselves states. Okay? And they did whatever they did. They created this thing called the Articles of Confederation. And that didn't really work out too well. So they sent a committee, they set up a committee to make some modifications to it. And the people who were in that committee said, well, this isn't going to fly either. Let's start over. And so they broke away from their original assignment, their original authority, became independent, started functioning as independent people, independent of the states, and they constructed this thing called the Constitution for the United States of America. Okay? Now, at the end of the Constitution, there's a little provision in there. It says, here's what we've presented. I'm paraphrasing. But it says, here's what we've come up with. We, the people, have come up with this. Now, if 9 of you states out there will come on board with this, it's a go. If we can't get 9 of you to agree with it, well, then we won't do it. Well, 9 of the states, in fact, it ended up being 13 states originally, came on board. They said, it's a go. But you understand, the people were a separate entity. They created this thing, and they invited these individual organizations to join in, which they did. And there's court cases that support that. There are court cases that say that the states contracted in, and there's no provision for them to break the contract, to get out. And they also said that the Constitution was created by the people and not by the states. Okay? That's a given now. So the people were sovereign in their authority. They created it, and when the people ordained it, that means make law. And when they established it, that means wrote it on paper. There is nothing that says they gave up their sovereignty. The people are sovereign. And when we say sovereign, we mean sovereign relative to the United States of America. Now, all of your state constitutions are written in a similar fashion. They say, various states, they say the people ordain or the people establish this Constitution, something like that. It's not written as beautifully as the federal Constitution is, mainly because many of their constitutions were written before. The United States Constitution is a very well thought out Constitution. The more I've studied it, the more I realize, boy, these guys were real brains. They solved a number of problems. There was also some holes in it, which are, I think, responsible for the problems we have today. But they did a real good job, considering the amount of time they spent. So this is where the fundamental definition of sovereignty comes from. This is what I base it on. Okay? Now, this is also, if you look at the preamble, you'll see that every element of a trust is in there, because that's what the United States of America is. It's a trust. It's a corporation. All corporations are trusts. Okay? They may not call them trusts, but they are trusts. So you've probably heard of a Massachusetts trust or a common law trust and a living trust. Those are trusts too. But corporations, a corporation for profit, a non-profit corporation, those are trusts as well. Yes? Is it over here?
Corporations that trust are all trust corporations.
No. But all you wanted to know if all corporations are trusts, but are all trust corporations? The answer is no. Okay? But there's a clever way, a very simple way to determine whether or not the organization is a corporation. One of them is that it could call itself a corporation. That's one way you can tell. Yes?
They call it, I heard a senator say, a corporate citizen. Corporate citizen is what they deem us. Or that.
Yeah, you can call that too, right. Okay, he's saying that he's heard a senator refer to corporate citizens, okay, that the citizens are corporate citizens. Okay, but anyway, the thing is that you can tell a corporation very simply. All corporations have president, vice president, secretary, and treasurer. Well, the vice president is optional, but they have the secretary and treasurer. Well, what's the United States? Has a president, secretary, and treasurer, right? As well as a vice president. And not only that, well, also a country, a true country, has a governor because he governs for the people. Okay? So the United States is actually a public trust, a corporation, and you can see the elements of a trust. Who's the trustor? Well, it's the people, we the people. And what's the venue? It's the United States, the people of the United States. And what's the purpose? In order to perform a more perfect union and so forth. Okay? Who's the beneficiary? Well, it's to ourselves and our posterity. And what's the enabling action? Well, there's two of them. We ordain it and we establish it. Okay? Declare the law and bring it into existence. And what is it? It's the Constitution. And who's the trustee? The trustee is the United States of America. That's it. Okay? So it's a trust. So there's no authority on the part of the United States of America to take over the people. Simply isn't there. Now there was a case I remember a few years back where this little boy was he was being abused by his father. Okay? And his father, I mean, they kept calling the authorities, and the social workers came in and they made their little record, and their record showed a progressively more aggressive abuse. And finally it ended up the kid was killed by his father. Okay? And the record showed it, that he was just getting worse and worse. So the relatives of the child sued the state for failure to do something about this. And it went all the way up to the Supreme Court of the United States. And the Reagan administration, which was the one in which this case originated, they urged the court to hold the state not responsible. Okay? And that's exactly what happened. The Supreme Court said that there is nothing in the Constitution that obligates the government to protect a person's life, even if his life is in danger.
What's the case on that?
I don't know, but I remember it happened. There's plenty of cases. That wasn't the only one. There's others. Okay? See, there's nothing in the Constitution that obligates them. They only have a general obligation. They don't have an individual obligation. Now, that might sound terrible at first, but you know, let me tell you this. When you grant somebody the power to independently decide that you need protection, what happens if they decide to do something for your own good? Okay? You've all seen that cartoon with the gun pointing at you? I'm from the government. I'm here to help you. Right? So it's recognized, some of the greatest minds in history have recognized that government is pure coercion. Okay? You do not want to grant them the power to protect you on their own. They have, because they might overprotect you. What you do want, you want the government to be able to decide to help you if you ask them. To assist you, right. So if two real people are duking it out in the parking lot and there's a policeman nearby, he can't do a thing about that until one of them hollers for help. Now he can make a decision to help. But that's an independent decision. He could still decide not to help for whatever reason. So there's no nexus there. There's no obligation. So you should understand that. But look here. Here's what the courts have said. All right? The people of this state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Notice that. What rights do you have? Not all of them, but whatever ones you decide you have. You are the decider of what your rights are. It is your prerogative. See? You do not need a higher authority to define your rights. Your rights are self-defining. Remember, the United States of America used to have a nickname. I haven't heard it much lately, but the nickname used to be the Great Experiment in Self-Government. Okay? Because we are truly self-governing. We govern ourselves. We don't need someone to govern us. Okay? We don't need representatives. We may choose to delegate some work to a representative and have him do some stuff, but whatever he does is not obligatory on me. Okay? So if he screws up and does something I don't like, I can just ignore him. That's the theory. Okay? Now we also know that in actual practice, just like we've outlawed robbery on the streets, people still get robbed, even though it's illegal. So there's definitely a difference between theory and reality. But you have to start with the theory, and that's why we're in this room here. We've got to find out what the theory is so that then we can hold them to it as much as possible. So the theory is that we define our own rights. We are entitled to all the rights which formerly belonged to the king by his prerogative. Well, since there's no king, it becomes our prerogative. We've inherited that too. Okay? That was Lansing versus Smith in New York. Okay. This is more discussion of what I told you. The enabling actions in the preamble are significant because there is simply nothing in the use of those words, which is ordain and to ordain and to establish. There's nothing in those words that imply that the people relinquished any of their own power and authority. The people declared the law, they ordained it without taking away from themselves the authority to declare law again in the future. The people established the Constitution without taking away from themselves the authority to establish anything else in the future. In other words, the people give birth to the Constitution without giving up any of their own power and authority. What was before continues to be so today. If they're going to change that, see, if you talk to an attorney and you ask him what is the significance of the preamble, he's going to tell you that there is no significance. Okay? The Constitution is the body of it. That's what counts. The Constitution, the preamble means nothing. It's just an introductory paragraph. It, like putting flowers on something. So, but the fact of the matter is that the Constitution is a fork in the road. Okay? It's a fork in the road. We, the people, ordained and established this Constitution for you guys over there. Now, we, the people, are still here. Okay? We've created this thing. But if we so choose, we can leave our people position and go under the Constitution and operate according to those rules. But that's a choice that we make, not a mandate. Okay? That's very important to understand that this is what we do by choice. All right? If you owned a business, you created a business. You founded a business. You created it. I'm not talking about a corporation. I'm talking about a sole proprietorship. You owned the business. You created it. It grew. And it grew to the point where you had to hire a manager. So you hire this manager, and you tell him what to do. And you got to the point where you've got a reliable manager and reliable staff, and you decide to back off. You don't want to be that close to your own business anymore. So you say to the manager, I think I want a job as a janitor here. And so you go in, and he hires you in as a janitor, okay, and you clean a place, and you're happy with that. You're still the owner, but you're happy with that. Now, in that circumstance, you're voluntarily taking direction from the very people you've hired that work for you, right? And there's nothing wrong with that. If you want to do that, you're the owner of the business, you can do it. Well, by analogy, you got the same thing with the United States of America and the individual states. You may choose to be a citizen of the United States, just like you may choose to be an employee of your own company. But it's a choice. It's not something that's absolute. You can back off and you can say, no, I don't want to work there anymore. You know, I've decided to go back to being an owner. Well, that's what you're saying when you say you're going to be a sovereign. And let me show you, I'm going to take you back to an actual case which supports that idea. We'll go to republic versus democracy. Now, before I show you that case, I want to show you a little bit about this. Okay, in the Pledge of Allegiance, we all pledge allegiance to our republic, not to a democracy. Well, what is a democracy? That's first. I want to talk about democracy first. Here it is. A democracy is that form of government in which the sovereign power resides in and is exercised by the whole body of free citizens directly or indirectly through a system of representation as distinguished from a monarchy, aristocracy, or oligarchy, and by the way, as distinguished from a republic. Okay? This is straight out of Black's Law Dictionary, 5th edition. A lousy edition, but at least they got that right. Okay? 4th edition and earlier is a better dictionary. 5th edition, I like the 5th edition and later copies because they tell me what the policy is. They tell me what the powers that be want the attorneys to know. But the 4th edition and earlier is where I get the law and the cases and that type of thing. So, and then the older the law dictionary is, the probability is the better it is. I like Bouvier's Law Dictionary, and on the CD that I will be sending you, Bouvier's Law Dictionary is on it, the 1856 version. Okay, so it's a very good edition. I believe that is the edition that was accepted by Congress. Okay, anyhow, a democracy. Well, let's talk. What is a democracy? Well, basically, you can define a democracy as being 51 beats 49. Okay? In a true democracy, 49% of the people have no rights. Whatever they have is granted by the goodwill of the 51. Okay? There is no such thing as rights in a democracy for the minority.
In other words, mob rule versus...
No, not mob rule. It's organized. It's okay. It's majority rule, but it's whatever. It's voted on. Okay. So I know that's a nickname for for democracy, but in truth.
Excuse me, Bill. I wanted to ask you a question. Going back to Bouvier's 1800 edition, was that 1856 edition? Did you say that was that the entire edition that you had on the disc?
So far as I know, it is. So I think it's the entire 1856 edition. I know I had an 1856 edition I looked at, and I did look up a few words to check it, and it was word for word the same, so I assume I got the correct copy. I didn't create it.
I'm saying, is that the entire edition on the CD?
Yeah, that's what I'm telling you. I checked a few words, and it checked out. I didn't look at the whole thing, you know. I mean, I'm taking it on a certain amount of faith. But, you know, I did look up some critical words I thought would be important, and it was all there, word for word, the same as the printed edition I had.
All right.
So the Bouvier's Law Dictionary on the disc, I think, is complete.
Is the court of record there?
Yeah, you're looking at it right here.
Okay, that is it.
Yeah, you're looking. Well, I don't have. Oh, I don't know if court of record is in Bouvier's or not. Didn't look up that one. But anyhow, the point I'm getting at here is that a democracy is 51 beats 49. So the minority has no rights. The 51% don't need rights because everything's going their way in the first place. Okay? So you basically have a dictatorship of the majority. Now, that's a democracy. Now, let me explain a republic. Now, one more thing about a democracy. You'll notice it says that the sovereignty, where is it here? The sovereign power resides in the whole body. Okay? So you have your big argument over the issues, and then you vote on it. Whatever the whole body votes on, that becomes law. Okay? The minority, of course, loses out. The majority wins. But it's the whole body, and that is where the sovereignty is, the entire body. The individuals do not have sovereignty. So whatever the majority says, that is mandatory on the minority. Okay? Bush was correct when he said he had a mandate if he won the election, or when he won it. There's some argument going on still about that. But, okay, he says he now has a people's mandate. And you hear that from politicians all the time anyway. They've got a mandate. That's because they're talking about a democracy. Now let's look what you have in a republic. Now, it's interesting that in the law dictionary, the 5th edition, you can look up democracy, but you can't look up republic. Okay? You have to look up government first, and within the government definition, they have republican government. Okay? But here's what it is. It says, one in which the powers of sovereignty are vested in the people and are exercised by the people, either directly or through the representatives chosen by the people. So the powers of sovereignty are vested in the people. They exercise it, yeah. But they have a choice. You can either go fill the pothole yourself in the road, or you can delegate it to your representatives and have them fill the pothole. That's the difference. In a republic, now the word people is both singular and plural. People is not the plural of person. The plural of person is persons with an S on the end. So that's the proper court English for those words. The word people, you can be a people, or several of you can be people. Okay? And this is important because if the sovereign power resides in and is exercised by the, if the powers of sovereignty are vested in the people and are exercised by the people, either directly or through representatives, you've thrown out the whole electoral process, if you wish. Well, I claim that I'm sovereign. Now, if I'm truly sovereign, I'm going to do what sovereigns do. Well, we've already learned that one of the things that a sovereign does is he decrees the law. Well, I'll tell you what else he does. He has his own court. Okay? Now, you can conduct your court over at McDonald's, or you can conduct it in a government building. After all, you're one of the owners of the government building. And if you meet, remember, you hired these people, actually not people, you hired these persons, okay? Now that you're educated, I have to be careful how I speak here. But you've hired these persons to do a job for you. They studied it. We paid them to do it. They've worked out a system. And so you might as well use it. But just like taking a job as a janitor in my own company, I can pick and choose when I want to yield my authority and when I want to retain it. So I go to court, I file my paperwork in, and I immediately put them on notice. In the very first paragraph, I put them on notice that this is the sovereign speaking. And this is a court of record. Okay? So what's the basic definition of a court? The basic definition is the person and the suit of the sovereign. So that's what a court is. Well, I'm one of the people, and in this court of record, I make my complaints. So I'm the king. And they accept it. You can file it in. You look at my paperwork, and it looks almost identical to what an attorney would write, excepting for a kind of some small details that everybody fails to notice except me. And that is that in there I said I'm one of the people, and this is a court of record. So as one of the people, that means, and this is a republic, okay? So as one of the people, I choose to do the job myself. I feel that this case is far too important to trust to judges and attorneys. Okay? So I take care of it myself. Who was it that said that war was too important to leave to the generals? You know? Some president said that, I think. And it's the civilian power coming back in. Or in this case, it's the sovereign power coming back in, because the federal government has no sovereignty. The state government has no sovereignty. The only sovereignty is in the people, and they borrow the power. That's why they're called government agencies, because they are agents of the people. Okay? So we have here a Republican government, and I choose to exercise my power directly. Now, let me explain the word power. There's physical power, you know, where you can pick up things, muscle power. That's not what I'm talking about. The legal definition of the word power means the law. And you are the originator of the law. So when I say you have the power, that means you are the legal source. You're the source of the law. Okay? And that is what follows from a Republican form of government, because it says it's one in which the powers of sovereignty are vested and so forth, and they're exercised by the people either directly or through representatives. Well, it's your choice. I choose to not exercise through my judge representatives. I choose to exercise them directly. I'll sit on the throne. I'm the king. Okay? Does that make sense? Am I? You got the point. All right. I want to be sure, because that's really, really important that you understand that. And it's important that you internalize it. It isn't enough to have intellectual knowledge. You've got to actually feel that. You've got, you know, let me show you this. You know, you walk into court, and I get a lot of questions from people about, you know, gee, what can I do in the court and so forth, you know, that type of thing. And when and to certain types of questions, I say, well, you're the sovereign. You decide what to do. Okay? Well, but they have trouble with this. They wrestle with this because, frankly, in their heart, they still feel that the legal power is over there in the judge, and they don't have it. So, but let me rephrase this a little bit. I'm going to bring in another analogy. You have a home. Okay, you're in your home, the door is closed. I walk up, I don't even bother to knock. I just walk right in. I walk into your living room. You're sitting there enjoying TV. What would be your first reaction to such an invasion?
Repulse.
Absolutely, repulse. What are you doing in here? Get out, right? Wouldn't that be it? By what authority do I presume to just invade your private home? Okay? It's worse if I'm a stranger. But, okay, well, the reason I bring this up is because in your hearts, you had an instant reaction on that. You knew exactly what to do. Okay? Somebody comes to your house, you knew it's out and now, right? And you will do whatever's necessary to defend your home. It's pure right that you have. Well, that's because you've internalized that logic. It's part of you. It's in your gut. With this, you have to get it in your gut. It's not enough to have intellectual knowledge. So, yes.
Yeah, as you know, I internalized that last month, and I reached the wrong spot, though.
Well, yeah, you've got to know what you're doing.
I've got to relax and wait until you get to the court position to really internalize it fully.
Yeah.
Because
that's right.
lands you in jail on the road.
Yeah. Well, you have to, you know, if you get stopped by a cop and you're saying, what the hell are you doing stopping me and so forth, he'll say, well, I'll show you. I got that lesson real fast when I was about 19 years old.
Good lesson.
I was dressed in a suit, tie, vest. My arm was in a cast. I was carrying school books, and I was hitchhiking in a legal way. I was doing it properly, so there was no probable cause. Cop stops, and he wants me to show him some ID. I told him, I'll be happy to show it to you if you'll tell me why you want to see it. Well, it was all downhill from there. I got arrested on suspicion of burglary. Okay? No charges. I was let out the next day, you know, and so forth. Yeah, but, you know, when you don't tangle with them on the street, okay? You tangle with them in court. So yeah, you've got to use a little bit of judgment here, because although you have the quote power, you don't have the physical power. Okay, they still have the guns. You got to take that into account. You have to deal with real world. You had a question? No.
Yeah. No. You said you were talking about getting arrested on suspicion of burglary.
Mm-hmm.
I got arrested once and let go with a ticket for burglary,
Mm-hmm.
or not burglary, but being arrested for trying to rob something. Okay, It was.
Well, we don't want to go into the details of the case, but you know.
But yeah, it's like I went to court. Yeah, totally bogus.
Yeah, well, look, they know how to lie.
A ticket.
Okay.
I mean,
so
a ticket. Let go on a ticket.
Yeah. The lesson here is that it goes back to that example about the Buddhists who are burning themselves. Okay, you've got to be on friendly terms with these people. You got to understand that they're only persons while they're on the job, but when they get off the job, they're people too. And they sometimes have attitudes, okay? And sometimes those sovereign attitudes carry over into their jobs, and when they shouldn't. And so then what they do is they issue tickets for strange reasons or whatever. You know, they stir up trouble in your life. Okay? So you got to deal with reality, okay? Don't think. And I went through this phase one time. I was just hoping I'd get a ticket. You know, I wanted to show them. Now, you have to learn that there's a big difference between legal power and physical power. And they can make life pretty miserable for you. So be sure to keep good social relationships. This is kind of a different subject, but it's related. There was a study done on why people get fired from their jobs. They found out that only 5% of all people fired from their jobs were fired because of incompetence on the job. The other 95% of the time it had to do with social reasons. Somebody didn't like somebody. That applies. That's human nature we're talking about. Human nature in action. And the same thing applies when you're out there on the street with a cop. You better socialize. Let the man have control for the moment, okay? Now, that's the first thing. My first objective when dealing with a cop is to let him have control. Let him know he has control. Let him know I'm not a threat to him. Let him know that I'm not trouble to him, okay? It's just a traffic stop, normally, all right? But I just let him know. It's after I get him comfortable with me that I then will institute some of the protections, like I'll assert my rights. And even then, I do it in a friendly way. I ask permission to assert my rights, okay? If he says no, that's fine. He had notice, didn't he? That's all it is. Man has notice and he refuses to follow through like a reasonable man would, he's in trouble downstream in the courtroom, okay?
What was funny is when he arrested me, it was right there on the spot. He
Yeah.
arrested me, he put me right
Yeah, that's all normal, okay? That's normal. Nothing special there. Okay, let's move on this. So the sovereign, like I said, the sovereign power, the powers of sovereignty are vested in people and exercised either directly or indirectly. Now, let's get down to that case I promised you earlier, okay? I'm in the wrong file here. Let's go to sovereignty. Okay, reservation of sovereignty. This was a very interesting case, and this case is the one that supports the idea that you can be a citizen for some purposes and not for others. What happened was that there was an Indian tribe that went into a contract with a corporation to do some mining. The corporation brought in all the equipment and started, set up the operation and started hauling the minerals off the land and to wherever. Well, after they had this going operation, and they were splitting the profits, okay? That was part of the contracts, that the Indian tribe would get a certain amount and the company would keep a certain amount. Everything was fine. Then one day, the Indian Council had a meeting. The Indian Council decided that we should have an extraction tax. Okay? So that way the corporation would have to pay the extraction tax. Well, the corporation squealed real loud on that one, and this case ended up all the way in the Supreme Court. The Supreme Court said, and here it is, it said, it is one thing to find that the tribe has agreed to sell the right to use the land and take valuable minerals from it, and quite another to find that the tribe has abandoned its sovereign powers simply because it has not expressly reserved them through a contract. To presume that a sovereign forever waives the right to exercise one of its powers unless it expressly reserves the right to exercise that power in a commercial agreement turns the concept of sovereignty on its head. Okay? Now, you're talking about Social Security contracts, you're talking about vehicle code contracts. Yes, ma'am. Well, there is. That's right. It's supposed to be hard. Yeah. Okay? They don't want you to understand this stuff. Okay. All right? But the bottom line is they went into a contract. Okay? But in the contract, they failed to reserve their sovereign rights. Doesn't make any difference. You still have them. Okay? You still have your sovereign rights. So just because you have a Social Security agreement does not mean you're not sovereign. It does not mean you can't open up your own court and sue somebody. Okay? That's the value of that case. Now, what's interesting is I've cited that, or let's put it this way, I've put that case in my paperwork, but I've never argued it. Okay? I just put it there for them to read when I put it in. Yes? Well, it is Marion, spelled M-E-R-R-I-O-N. Here, I'll just make it larger for you. Let's try this. I think it's up here somewhere. Okay. Can you read it now? Here, I'll bring it to the top. Marion, M-E-R-R-I-O-N, et al., that's E-T space A-L period, versus Jicarilla Apache tribe, J-I-C-A-R-I-L-L-A, Apache tribe, et al. That's probably the best site would be 455 US 130. You'll be able to find it that way. Okay, and you'll probably find it on FindLaw. Everybody familiar with FindLaw? No. Okay, you go to www.findlaw.com. You can do free case research back to 1834. It's a great one. You have to register with them. It's a free registration, and then you get the full case printout, of whatever, or the full decision printout. Okay. All right, but that is the case that confirms. It doesn't decide, but it confirms that sovereignty is permanent, and you can choose to go into a contract. That's what citizenship is, okay? Citizenship, you know, you've heard that citizens have duties they owe to the government. Well, the government has duties it owes to the citizens. So, but that's a contract. quid pro quo. And the sovereignty is still there. You can pick and choose when and where you want to be a sovereign. I don't buy into the idea of sovereign citizen, however, because the sovereign is the master, the citizen is the slave. Okay? So there's no such thing as a master-slave, I don't think. Okay? I just don't see it. Okay, but that's your sovereignty. So let's go back to the top here. Any questions about that?
Bill?
Yes.
Back there in your definition. Come on, Mike, over here, and we'll get about people. Maybe you already covered this, but I was out for a while. Back there, when you were defining democracy, I should say Black's Law Dictionary was, and it referred to the sovereign power, but then in the after that, it also referred to the free citizens.
Well, a free citizen is not a citizen at all.
Right.
Not if he's free. Yeah, yeah. I mean, they throw words around like that. But see, what my method is to stay simple, okay? And I avoid terms that deviate from the high-value terms that I've found. For example, the word people I consider a high-value term, okay, because it's in the preamble. See, that preamble gives you a fork in the road, as I mentioned earlier. You can either go down the road of sovereignty, because you're one of the creators, or you can go down the road of being a subject, being a citizen. And it's your choice. That's the beauty of it. It's your choice. These founding fathers really figured this out. They gave you a choice. You could go either way. Frankly, it's very convenient sometimes to just be a citizen. I mean, when I drive on the road, or I should say when I travel on the road, okay, I travel like a citizen. I obey all the rules. And I don't necessarily do it because if I don't do it, I'll get a ticket. I do it because it makes sense. I mean, everybody agrees to go down the right side relative to themselves, the right side of the road. Everybody agrees to stop at a stop sign so that, you know, we hired these guys to figure out these rules. Let's follow them. All right? So I'm comfortable with that. My discomfort comes when they start lording it over me and start abusing the authority that I granted to them. They're pretending to pull rank. Okay? Nobody likes anybody who pulls rank. I mean, I've seen enough supervisor scowls in my life. You've seen it. Somebody's doing something and the supervisor's off in the corner kind of scowling, looking at what's going on. You know? No, I like people who are down to earth, straightforward, you know, not sneaky, and not abusive of their authority. The supervisor has a job to do just like anyone else. So I respect that, but don't lord it over me, you know. Okay? Yes?
Bill, what do you think of people that gold plate their cars?
Why not? It's a free country, isn't it?
Oh.
I think it's wonderful. If you can
Okay.
afford the gold, go for it. Yeah, you know, that's the thing about freedom, is that, look, do anything you want as long as you don't push me around. Yeah. And the same applies to me. I do anything I want as long as it doesn't invade your sovereignty. And it's great. But now when we go to court, they're not accustomed to sovereigns being there. And so you have to assert yourself. So this is how we do it with these rules. I quote these rules because these rules, they've taken an oath to obey. See? That's the difference between them and me, one of the differences. I'm not obligated to that. There's a guy I know who was attempting to assert his sovereignty. Unfortunately, he had not internalized it yet. And I'm warning you that you got to do that. And he was in front of the judge, and the judge said to him, "You're claiming that we don't have any jurisdiction, and yet you're citing all these codes." Okay? And he didn't know how to answer that. But the proper answer was, you took an oath to obey those codes, And that's why those codes apply to you. I have not taken the oath. I'm in my sovereign capacity. I'm the source of those. Okay, that's what he should have said, but he didn't, and he went to jail. He had his bail revoked. It wasn't revoked. It went from 70,000 to 700,000, and so on. So he's in jail for a long time so far. I haven't heard any more in that case, but I had worked with him a little bit, and I told him, I explained it to him that when I was working with him, I explained to him, we're citing these codes. The authority comes from you, but the words come from there. He didn't get it. Okay? So you have to internalize it. How do you internalize this stuff? Well, it's easy to tell you how, but it's hard to do it. But here's what you have to do to internalize this stuff. What you have to do is you have to teach someone else. That's the key. You have to teach someone else to internalize it. The doctors have a formula. Medical doctors say, see one, do one, teach one. They see a surgery done, then they actually do a surgery while they're being supervised, and then after they've had their practice, they then teach another doctor how to do surgery. And it's when you teach it that you lock the information into your brain. That's what you've got to do. I absolutely suggest to you that you do not do your papers on your own. Work with somebody, because that person is going to make you explain everything to him just like I'm explaining it to you. And you're going to get stumped sometimes, and you're going to have to think through it. And when you go through that process of working through, and you say, I saw that somewhere, and you go back to the disk and you search or whatever you're going to do, that's what gets it into your brain. Until you've done that, all you have is intellectual knowledge. You've had your exposure, and you wasted your money coming here. Okay? So, but if you will follow through and actually work with somebody, work with them on their cases, have them work with you on your cases, you'll go back and forth. What one person forgets, the other person will remember. Okay? And that will drill it into you. That's what I did. I thought I had a pretty good understanding until I started helping people. And they threw questions at me. And I was very, very lucky. I was in a situation where I had to help a whole bunch of people. And I ended up getting involved in about 150 cases. And we made our mistakes. Some people went to jail. Some got out. Okay? You know, it's the price that's paid to get knowledge. Okay, I heard the lunch call. Let's do it. You want to? Shall it be a 1-hour lunch?
Yeah, 40 minutes.
Okay.
40 minutes.
All right, I'll tell you what.
We're going to vote on it? 2 o'clock?
Well, we're going to take half. Hold on a second here. We'll take half a vote, okay? The folks who came the long distance, like from Oklahoma and Ohio, and they're the guys who spent the big bucks to get here. They should decide how much time they want me to spend and how much time they want to do for lunch. So what do you say? 40 minutes? 40 minutes? Let's do that. Yeah. Yeah, two, all right, 40 minutes is 10 minutes to 2. 10 minutes to 2, okay? Okay, we're live. Okay, we're on. Okay, any questions? While we think of any questions while you're eating?
What kind of bird is that?
For one thing for sure, just looking at it, it's not flipped.
It's not what?
Flipped. The bird is not flipped. So, all right. I passed out to you, I didn't get it from everybody, these things. Tear off the bottom and let me have your address so I can mail to you the CD. Okay, just rip off the bottom portion of it.
You want the zip code? You didn't ask for it.
No, I don't need. I don't care. You know, you tear along the dotted line, okay, on it. So if you haven't done it already, otherwise you won't get the CD because I won't know where to send it.
I didn't tear off the bottom.
Did you want to? Okay. Okay. Thank you. Oh, then I tore it off for you. Yeah. All right. So there's that. Okay, thank you, sir. Great. Okay, thank you. Okay, sovereignty. That's what we're on. Let's see where we go with this now. Let's go to... Let's see, language. All right, so far, I've brought out that it's important what language, which version of English you're speaking, and we try to stay as much with legal language and specifically the Constitution. So there are many terms that they try to get you to use, but when you use those other terms, there's traps. And the trap is that you might be saying something you didn't mean. So I look at the Constitution. What does the Constitution says? Well, it has the preamble. And it only talks about people, not citizens, in the preamble. So I use the word people. I don't know the word citizen. Okay? The only other place where I see a commitment on the word citizen is in the 14th Amendment. And the 14th Amendment basically says that if you are born or naturalized in the United States and subject to the jurisdiction, then and only then do you qualify as a citizen of the United States. Well, I don't mind being subject to the jurisdiction if I'm actually got a contract going, a quid pro quo, I get something for something. But there's no general citizenship for me. It's a pick and choose type citizenship, which I am entitled to. But normally I retain the peopleship. Okay? So I'm one of the people of the jurisdiction, and I'm only a citizen for certain specific purposes that are of my choosing. And there are examples. You know, I look at myself as the owner, one of the owners of the system. And so I've hired some of these people to do things for me, to research things for me, and they come up with solutions to problems. And as a general rule, I'll respect those solutions. So I do respect the vehicle code to quite a bit of degree because it basically makes sense. It's essentially mostly around safety. Some issues like where they get into commercial, I'm not familiar with because I haven't gotten to those areas. I don't know, maybe my opinion will change once I get into those areas. But as things stand right now, I have no problem with driving on the right side of the road, stopping for red lights, stopping for stop signs, you know, that kind of thing. And but if a policeman comes along and wants to generate issues, create issues out of nothing, well, that I object to. And that's beyond what I've authorized him to do. And so that's kind of the basic perspective I have. This, but you have to have a clear picture whenever you're involved in anything, a clear picture of are you one of the people or are you one of the citizens? Or are you one of the persons, which is synonymous with being a citizen? If you're a citizen, you're basically a ward of the state. If you're a people, then the state is your ward. Okay? But you have to have that clear distinction. So that's an important point. Are you one of the people or one of the citizens? Let's go down to, here, let's see. We went through the preamble of what the various elements of the preamble are, and I mentioned to you that there's the fork in the road. So let's see, I think we pretty well covered that. Here's the 14th Amendment, just to confirm what I just said, which is that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Can I enlarge that for you? No.
Bill?
Yes.
Can I ask a question on this?
Uh-huh.
Would you like it on tape? It's important.
Oh.
It's important. People might want to hear later. You might do it.
I am a people of the country of Canada.
Okay.
And I domicile here in California. So if I was in court stating my case, would I just say I'm one of the people, or would I have to say I'm one of the people of the country of Canada? Or?
Well, one of the things I advocate, because I feel that it strengthens your position both morally and psychologically, and that is to always tell the truth, okay? We're not looking for ways around the system. We're looking for ways to make the system work as intended by the founders. Where I know that there's a standing invitation that Canada, anytime it wishes, can become a part of the United States. That's just a standing invitation that was included. I don't know if it's legislated or what, but we had very good feelings toward Canada. King George learned his lesson, and apparently he treated the Canadians better than he treated us, and so they decided to stay with the king. But after saying that, I also have to say, once again, my great leader, Abraham Lincoln, said, if you don't want to argue a point, don't bring it up. So if you wish to brag that you're a Canadian citizen, well, then I don't know what rules kick in on that basis. But I do know that the courts do not consider anything that's not brought up. Okay? Whether it's brought up publicly or secretly, it's not considered unless it's brought up. So if you are here, you're functioning in our society fully, you have permission to be here. You may not qualify for citizenship because you haven't been naturalized, but it doesn't say in the Constitution that you have to be a people first before you can be a citizen. It just simply defines a citizen of the United States as somebody who's born or naturalized and subject to the jurisdiction. So my guess is that if you simply went into court and said you're one of the people of California, I don't know that there's any legal requirement per se, because, see, people of California existed long before the immigration laws were passed. There was a concept that, you know, if you're one of the people, you're influencing the system. At worst, I would consider you a visiting sovereign. You know, and if somebody offends you as a visiting sovereign, I assume that you invoke your court and you move accordingly. And you follow, because you're a visiting sovereign, invoking the common law, which, by the way, is the common law of England, which is recognized. The Constitution of the United States recognizes the common law of England, which is equally foreign to us, right? So it's the same law that they recognize. My guess is that you could just move forward. I don't know if is Canada a republic?
Yeah.
It is? Is it constitutionally defined as a republic?
I don't know.
Well, see, that a republic, the sovereignty is in the people, and the people can choose to act directly or delegate it to representatives. Is that how Canada works?
I believe so.
Well, that's not strong enough. You know, you need more than belief.
I have to know.
You have to have knowledge. But like I said, at worst, I'd consider you a visiting sovereign.
Okay.
And you know, so anybody who offends you, causes you an injury, then you're entitled to redress, and under the common law, it's a maxim of the common law that there will always be a remedy for every wrong.
Okay, thank you.
So, that's the beautiful part about common law. There shall be a remedy for every wrong. There's no such thing as not having a remedy like there is in the statutory system. Statutory system, you have an injury, everybody knows it's an injury, but say, well, there was no law against it. When you're at law or in law, you decree the law, you prosecute. Yes, sir.
Yes, Bill, you refer to, and quote Abraham Lincoln quite often, and you know, the last 5 or 10 years there have been several books come out and saying he was such a traitor to our country, but personally, I feel that if they'd ever divided America like they tried to, it would have been very easy to conquer one segment of the country, and then the next segment, first the North and the South, if they'd ever divided us. And I was curious
that's the concept
how
of the
you
union.
feel about Abraham Lincoln as an attorney, as a people rather than as a citizen.
Yeah. Well, I keep referring to Abraham Lincoln, but I'm referring to him in the context of, if you don't want to argue a point, don't bring it up. That's the point I'm trying to get across, and he said it, and he's right, as far as I'm concerned. You know, I don't. When I go into court, I create my papers. I don't say to people, "I'm sovereign." I don't say that, you know, like that. I say it indirectly. I say I'm one of the people. Nobody argues that. Okay? I don't say I'm a king because I figure I'll get an argument, even though it's true. Okay? Legally speaking, every one of us, every one of you is a king or a queen. So but instead of saying that, I use the word that's used in the Constitution. I'm one of the people. And I choose to go down the pathway of sovereignty. And so I cite the cases that say, that acknowledge the sovereignty of the people. You know? So I get one step removed from the word sovereignty, but that's what prevents argument. All right? And like I said, I've never had anybody challenge me in my papers on that point that I'm one of the people. I say I'm one of the people, they accept it. Well, we move forward. That's an important aspect. You know, a lot of this legal work in courts is very analogous to two little kids in the backyard screaming at each other. One of them says, "Yes, you did," and the other one says, "No, I didn't." And it goes back and forth. "Yes, you did." "No, I didn't." "Yes, you did." "No, I didn't." Who wins that argument? The last one who speaks wins it, right? Well, that's how the courts are. We had a hearing the other day in this case, and the jurisdiction was being challenged, and the judge sat there, and we're suing judges, okay? And he said, well, the judges have absolute immunity, judicial immunity, and also the claimant failed to put in a claim against, you know, through the claiming channels, but instead went directly to a lawsuit. Well, the lawsuit claims that the government is innocent, and that it's the people in it that were acting entrepreneurially. They were on their own. And so, anyway, but the judge just covered those 2 points, that they had immunity and no claim was filed with the claims department of the government. So, and then the judge ordered the defending attorney, defending the judges, to then put together the order, and he would sign it. Okay? Well, before that happened, we filed in the order of the sovereign. Okay? We ruled against the judges. And we said, no, you're not out of this suit. You're not dismissed from the suit. You're still part of it. Now, we haven't heard their response to that one yet. But you see, we screamed first. Okay? On paper. Yes.
Who is protecting that? Who is defending the judges? Is it the county?
An attorney. Yeah. Oh, Lockyer.
Private attorney?
No. Public attorney.
Public attorney.
Yeah. The Attorney General. We put it in our answer to their demurrer that we thought it was rather strange that I think we said public funds were being expended for, a private defense. We did mention it. We didn't make an issue of it. We just mentioned it as an aside. In fact, we said that as an aside, and then we just kind of mentioned it, okay? But, yeah, oh yeah, it's part of the paperwork. So it should be interesting with time, yes.
Something that always confused me is how can...
Microphone. Yeah.
I could talk loud enough, but it's not for these people, it's for the people who talk later. One of the things, questions I always had was, like in IRS cases, how come the U.S. attorney is prosecuting a case against we the people for the IRS, who isn't even, a government agency?
Well, it's a commonly done thing in all high management levels. It's a very common thing that executives will be on loan to other companies or other operations while staying on salary in their own. That frequently happens. That's a pretty strong custom that you're not going to buck. But
shouldn't they be really defending the people that are accused?
But what they've done is the Attorney General, he carries his title with him, but he is a private attorney for a private outfit called the Internal Revenue Service. And people don't understand that, of course, and don't raise those issues. But yeah, you could challenge that. Okay. But it's kind of like a side issue to the main thing. The real question is what jurisdiction do they have in the first place? Okay. Now, there's a lot of little aside here. We get lots of little asides here, I guess. But if you look here, you'll see, where is it? Find it here. Here it is. Internal Revenue Code. (7806). If you look at Title 26, Section 7806, 7806 says, right here, that Title 26 is not law. Okay? And if you want the actual wording, let's take it up. Can everybody read that from the back? Yeah. You want a little larger? How's that? I don't know how large I can go. Now can you read it? Yeah. Sort of. All right. It says, no inference, implication, or presumption of legislative construction shall be drawn or made by reason of the location or grouping of any particular section or provision or portion of this title. What do you call presumption of legislative construction? What's the three-letter word that describes that? Law. You can't make any assumption that the Congress meant anything by this just because they passed it. Okay? When I got my passport, I applied for a passport. And I filled out all the forms, and then on the back of it they have this dire warning. If you misrepresent, if you fail whatever it is, you could be prosecuted for failure. They want things like your name, address, and social security number. Well, in the little box it says social security number, I wrote in exempt per 26 U.S.C. 7806. Yeah, per. 26 U.S.C. 7806. Title 26 is the Internal Revenue Code. Okay? If it's not law, then you're not obligated. Right? So you ask the IRS, what's their authority? They say, well, it's the Internal Revenue Code. Okay, I accept that. That's your authority. So you do whatever you do, just as long as it's not against me, because I'm not obligated. Because 7806 says it doesn't apply to me. Doesn't say it directly, but it says it's not law. You can't presume it meant anything. Legislature didn't mean anything by it. Right? You can't make an inference or an implication. Does everybody here know the difference between inferring and implying? Okay. If I say something to you and I put the meaning on it, I'm implying. If I say something to you and you put the meaning on it, that's inferring. Okay? So it's all which side of the conversation are you on. So you infer what you hear, the other person implies what he says. So it says here, you cannot infer or imply. No inference, no implication, and no presumptions of legislative construction. That's all I've ever done. I don't know, you know, I hear about 861. Anybody heard of 861? Yeah. I've heard of all these other things, and I say, you know, this is awfully complicated. I can't understand it. I really haven't gotten it. I read some of this stuff, but you know, it's such a logical structure I have to hold in my brain. I can't deal with it. It's really difficult. So I don't. I just go back to 78.6, or whatever it says doesn't apply here. Okay? Cut them off at the gate. You'll find that this stuff, if you go right on target and you look at the very roots of these things, so that's why I go. I say, I'm a people. That means I'm sovereign. What does sovereignty mean? It means there's no higher law. I am the lawmaker in my kingdom. My kingdom is more commonly called my house. Okay? But I'm the lawmaker. And no one else has a law above me. Now, there's actually a biblical foundation for this. Okay? Now, the American system of law is very much based on the Judeo-Christian rules, philosophies, concepts. Okay? Never mind the religion aspect, just simply this is where we get the 10 Commandments and how we've structured our laws, the foundation. We did not structure our system based upon Buddhism, okay, or the Quran or anything else. No, we have our own system. It's an equally valid system, I think. And if you look in Genesis, the story of Genesis, we have, it says that I think the, what do you call it, not the snake, but the serpent. The serpent inquired as to why it was that she couldn't eat of the fruit of the tree of knowledge. And, huh?
Tree of the knowledge of good and evil.
Right. And so, tree of knowledge of good and evil. And so, Eve corrected him and said, no, it wasn't that they couldn't eat it. No, she said they were prohibited because they would die, I think something like that. And it was the serpent that corrected her. The serpent told the truth. The serpent said to her, it isn't that you will die, it's that if you are to eat it, God knows that you will then know good and evil.
No.
Pull out your Bible. I've studied this one.
The serpent says, you will not, he didn't say that the Lord knows that if you eat of the tree, you will become like God. Just like God.
He didn't say become like God, he said as gods.
As God.
Right.
Or
yeah.
Well, that's
yeah.
That's
but he told him that you will be.
Just like.
He said you will become as gods and that you will know good and evil.
Yeah.
Okay. We're on agreement now. Okay, that's the final statement. All right. Then later on in Genesis, God discovers that they've eaten of the tree of knowledge. And he says, behold, these are God's words, and this is almost a good quote. Behold, the man is become as one of us, in that he knows good and evil. Now, what does become as one of us? That means you're equal, okay? You're not equal 100%. You're only equal in this little narrow area of knowing good and evil. Now, why is this important? Well, what makes it important is this, is that if I come up to you and I say, you know, you're wearing pink shoes, and that is wrong and evil, okay? And then you say, what's it to you? You know, you're not better than me. That's probably a reaction, which by the way, I don't approve, but that's probably what you would say. And so then I come back at you and I say, well, it's not me. I'm just delivering the message. God told me to tell you that it's not good, okay, that it's evil. Well, if in fact you are as God in knowing good and evil, you could come back and say, the fact that it comes from God tells me that it's very good advice, but I respectfully disagree. I like pink shoes, okay? That would be your comeback. So you see, there was really no basis for the Inquisition, okay, during the Middle Ages. But they carefully ignored that aspect. But God, you have become his equal in that narrow area of knowing good and evil. And this carried over into our legal system. And so if you know the difference between good and evil, then you, and because you have your sovereignty, nobody can tell you what's good and what's evil. You have your own opinion. Nobody is entitled to take command of your life if you don't want them to. Now, there's an exception to that rule. And back in the times of Greece, they had juries. And they had juries. Each jury consisted of 1,000 people. Now, the reason it consisted of 1,000, the theory was that no one was rich enough to bribe all of them. Okay? Their safety was in the numbers. Of course, Socrates got a death penalty as a result of that system. But this jury consisted of 1,000. Here in the United States, we've settled on a jury of 12. That's our system. And so we've said that if you have 12 people on the jury, statistically speaking, each juror represents 1/12 of the population. If you can get 11/12 of the population against you, but one's on your side, then we have to respect that. 1/12 of the population is a big enough group, so we have to respect the opinion. But if 100% is against you, then you must be wrong. That's how our system operates. And I pretty well accept that. I've served juries. I've served on a jury 3 times, and I know the difficulties in coming to an agreement, how it goes back and forth. Eventually you can, but there's a lot of discussion because people are very responsible in how they try to carry out that job. Not necessarily the smartest people or the dumbest. You know, I mean, there's a range of intelligence, but one thing's for sure, every member of a jury that I've ever dealt with has shown me real integrity of purpose on that particular case that we were working on. So I have a high confidence level in the jury system, and I'll put up with the random error of a jury long before I'd be willing to put up with the designed error of precedent that judges exercise. Okay, so anyhow, that's where we put the dividing line. So we are all equal. Nobody can come along and say, you have to do what it is, whatever, because I'm bringing you a message from God. Okay? That's been taken out of our hands. None of us is authorized to represent God with that kind of impact or authority. So now that's just another reason why we are all sovereigns. Okay? Yes. Okay, go ahead. Ask it over here.
Up there?
Yeah. You need the exercise.
On the jury part of it, in retrospect, my understanding is when they select a jury, they meaning the attorneys and what have you, they ask only a couple of questions if they're a citizen of the United States and those type of questions to become a juror. So as if you're one of the people being tried on a 12 juror, then you're being tried not of your own peers, but of another jurisdiction. So how would that apply to one of the people?
Well, I have no guaranteed answer on that, but there was a story I heard about 10 years ago or so where this guy in San Diego insisted on a jury of peers. Now, what's a peer? A peer is a member is a member of the peerage. So what's the peerage? Well, that's the nobility. That's the sovereignty. We were all sovereigns in the United States. We were all automatically promoted to the peerage. So the true meaning of the word peer is a member of the peerage, a fellow sovereign. When they created this new class of human being in 1868 with the 14th Amendment called citizen of the United States, we now have a two-level caste system. We have the people of the United States who own the country, who own the United States, and then we have the citizens of the United States who are owned by the United States. Okay? So we have that system. Well, this guy insisted on a jury of his peers. Well, they couldn't find anybody who would not admit that he was not a citizen of the United States. And so the judge ordered the sheriff to go out and find some peers. And he, of course, he didn't know where to look. He didn't know to come to a group like this. And so he had to report back to the sheriff or to the judge that he couldn't find any peers. They had to dismiss the case because they couldn't satisfy the demand for a jury trial. A jury of peers. I'd never tracked down that case. I would have loved to, but I'd heard that story. So that was in San Diego is what I heard.
I wouldn't advise trying it.
Well, you wouldn't advise trying it, you say, but why not?
I don't know.
You know,
There's other ways.
What other ways? I mean, you know, well, you can put on a seminar. Tell us. But, you know, the thing is that, well, you know, there's many different ways to skin a polecat, as the saying goes. And so that's just, you pick your strategy and you fight it out. All right, so going back to the foundation here. All right, so the question is, are you a people or a citizen? And is everybody at this point clear on this point of what the difference is between people and citizens? Do you understand that a citizen is under the jurisdiction, a people is over the jurisdiction? Okay? That's right, too. Well, there's levels of jurisdiction, so if the people own the country and the country owns the citizen, then, you know, the country has jurisdiction over the citizens. So, okay. Now then we covered a little bit about sovereignty. Let's go back to the sovereignty because there's more case law that you can look to. For example, here in California, now those of you from other states, look, the concept is solid. The people created the entity. And when they created the entity, they released none of their sovereignty. It was a creation, okay, or it was an ordination. So that's where your primary definition is of the relationship between people and government. But sometimes, like in California, it's legislatively defined as well. Now here in California, we have what's called the government code. And the government code basically is a set of instructions from the legislature to the public employees explaining to them what the government is all about. And I believe it's section 100, I think that's the section of the government code that says that the sovereignty of the state lies in the people. The sovereignty has no, it doesn't exist in the state itself. It has no absolute sovereignty. They can claim sovereign immunity, that's true, but only to the citizens. They're immune from the efforts of the citizens. But they're not immune to other sovereignties that are higher than them. For example, they're not immune to a Title 42, Section 1983 lawsuit based on violations of civil rights. Okay, the federal laws, you can walk right in. You don't have to make a prior claim to the government. You can sue them directly because they are outside of or actually under the federal sovereignty on those particular issues. And that's constitutionally defined, that the federal law is the higher law. So when you're sovereign, you're above the state also. The state's not sovereign. It's an agency, an agent of the sovereign. So you can sue them, and they cannot claim any statutory protections. You go back to the basic laws of common law. Now, why common law? Well, the reason is this. You see, as a sovereign, if you're truly sovereign, you can make up any fiction you want. You can make up any kind of rule system. The common law is just one way of doing things. There's other ways you can do things too. Other ways you can specify rules. So what you do, you go to the common law for one simple reason. If you look at the constitutions, or particularly the Constitution of the United States, the common law is recognized by the United States and will be enforced for you. If you have an issue that arises under the Constitution, you can then use the common law to enforce it, because the Constitution says the judicial power of the United States shall apply to all cases in law and equity that arise under the Constitution. Okay? That's why we want the common law. If we fit into the common law mold in our private law, they will back you with their judicial power. So that's what we do. But in California, we have the government code, and government code section 11120, more commonly known as the Bagley-Keene Act, is basically, its main focus is the conducting of public meetings among the public agencies. Okay? So they're not supposed to have private meetings except certain very narrowly defined exceptions. But they do have something here that's really neat, and I use it frequently. And what it is it says the people of this state do not yield their sovereignty to the agencies which serve them. Yes.
We have that in our Washington State RCW 4217-251.
You got it there too. In Washington, 4217 in 2. All right. Go ahead. Put it on the record here.
Okay, it's also in Washington State RCW is under 4217-251, which is our public disclosure laws, and it says that we have to. The government has to keep us informed, just as this does.
Right, but the real point is that the people of this state do not yield their sovereignty to the agencies which serve them. Okay, the courts are an agency. Okay, they are, when we act through the courts, we are acting through our representatives. Okay, but since this is a republic, we can choose to act on our own. We can act directly. You open up our so the people's sovereignty is definite, and we do not yield it. Yes.
Went to the Orange County Law Library and looked on Law Desk, and according to them, 54950 is still there, but 11120 was repealed.
Oh, 11120 is repealed because it's still on the legislature. LegInfo. They maintain a site, and it's still there. So I don't know when they appealed it or repealed it, but as far as I know, it's still there. But 54950 is still there, right? Okay. I kind of feel these two are sort of overlapping in what they did, but it says the exact same thing, word for word, identical. The people of the state do not yield their sovereignty to the agencies which serve them. So they've got a case going to you, and you walk in, you say you're one of the people, and when you do your counterclaim, there you have the exact way they have overrun your sovereignty. You see how they exceeded their jurisdiction. There is absolutely no authority anywhere that I've been able to find that authorizes them to prosecute people. They can prosecute persons, but not people. Okay? Now, of course, there's always the fight to get that enforced, but still, that is the black and white letter of the encoded law. That's known as the Ralph M. Brown Act. I'll check out that 111-20 and see if it has been repealed. And anybody listening to the DVD should check it out too. Make sure. That's another thing. The rules do change. So whenever you do a case, and I know this is hard to do, but you should always take, if at all possible, a fresh check on the status of things. No point in quoting something that doesn't exist anymore. But thanks. Okay. All right, so that's that part. Let's see. Black's Law Dictionary defines sovereignty: the power to do everything in a state without accountability. In other words, there's no higher law. It's to make laws, to execute and to apply them, to impose and collect taxes and levy contributions, to make war or peace, to form treaties of alliance or of commerce and with foreign nations and the like. Okay? That is not the law. That isn't even a dictionary definition. It actually comes from Story's constitutions. Whoever Story was, he was a writer, legal writer, and I guess he wrote a book on the Constitution. It was Section 207. You can look it up there. So he's a highly respected source. Okay? Sovereignty in government is that public authority, which, notice that, sovereignty in government. All right? Again, the real sovereignty is in the people. But if you have sovereignty in government, it means sovereignty only in those areas where it has been granted permission to act. Okay? To that extent, they have sovereignty, but they cannot go beyond it. If they go beyond their limits, they're eligible for a lawsuit. Okay? So its sovereignty in government is that public authority which directs or orders what is to be done by each member associated in relation to the end of the association. Each member, that's another code phrase for citizen. People are not members of the government. We own the government. I think there's another word they're using in government these days. I haven't locked into it yet, but the word they use now is stakeholders. Yes, sir.
Bill, you're quoting the 4th edition. How about more current editions? Do they change the definition of sovereignty?
No, they can't change the definition because sovereignty at the time that the Constitution was formed had whatever meaning it had. They can't change that.
So you're saying that the 5th
they might be able to fool you into thinking it's changed.
Okay. And was the more current editions don't define it this way, though, do they?
Well, I don't know. I can't say that for sure, but I think, let's put it this way. Just because a dictionary is published at a later date does not necessarily mean that the original definition is invalidated. Okay? As was pointed out earlier, Justice Scalia goes to original intent. He goes to the original meaning of the words to understand what was meant back then. And the same still holds in any endeavor of law where you're trying to apply precedent. Whether you use an old meaning or a current meaning, well, let me say this. Who's the tribunal in your court? Okay, so you're the ultimate judge. Yes. Go ahead, microphone.
Just a question.
Yeah, that's, yeah. That turns out that is a one-question microphone.
Stakeholders. What did you say about that? What is meant by that?
Well, that's a new word that's popping up in government now. I'm not sure what it means. I'm not even sure it has a legal meaning.
I noticed that, and I would like to know more about it.
So would I. I haven't seen it. I've heard it used, but I haven't heard it used in an authoritative method where I can track down and say, this is exactly what it means. I haven't found that yet. But it's from the mining claims, I've been told here. But I don't know. Okay? Something, yes.
Or it could come from the Inquisition when they threatened them with stakes and racks.
Sure. It could be. So you're a stakeholder.
And then you would be a stakeholder.
Or it may be that the top guy decided to use it, spends a lot of time at the barbecue in his backyard. I don't know. But the thing is I'm sorry. I know. You know, if I were punished for every pun I said, I'd need a puny shed in which to hide my punished head. Okay, well anyhow, yeah, but I'm just giving you a heads up. This is a new word that they're now using, including, I don't know what it means. Same way, another word that popped up a few decades back, and I haven't seen a solid definition, is the word regional. What's a region? I see it around, but I don't know what it is. Yes?
Bill, in the definition of sovereignty, the first line, the power to do everything in a state without accountability.
Right.
I don't understand that. Without being accountable for anything?
That's right.
So you could murder someone?
They do. It's called war. Definitely. It's called war. It's called putting down an insurrection.
Well, I know I've heard you say, you know, that in common law you're not supposed to injure anyone. So
well, that's right, but common law is not the same as statutory law. Sovereignty means there's nothing higher. Okay?
Nothing higher,
so
okay.
if you do, in fact, have sovereignty in government, then you can do anything you want. Stakeholder, first point, the word stakeholder. Second point, mining claim. Okay? Third point, mine. Fourth point, it's mine. To own. Therefore, the people own the U.S. That's the chain of logic he has. Well, could be. But you see, okay, so you're saying it comes from the mining industry, the stakeholder phrase. Okay, great. All right, but look at this. You see here we have a definition of citizens, all right? Now, whenever you're talking about the definition of the word, it's always good to ask who's the final authority on that definition. Now, if you follow the statutory system, the final authority would be the courts. Or, if it gets appealed, the appellate courts. Okay? That's the final authority. If you are running your court, you're the sovereign of your court, then you're the final judge as to what a word means. You ever heard about having your name in all caps versus upper and lower case? Well, I know it happens that when I put together my legal paperwork and I type it up and I'm the plaintiff. And when I'm the plaintiff, I type it in sometimes all caps, sometimes upper and lower case, depending on my mood, okay? Now, who is the tribunal in my court? Right. So that definition doesn't hold water in my kingdom, okay, or my court. That simple. It's really wonderful when you get the feeling of this, you know. Who's boss? And you have to have that clear definition. Are you the plaintiff? If you're the plaintiff, you're the boss. Don't ever let go of that. And if they try to do something, object when you're in the courtroom. And back that up with a court order. Okay? Now, speaking of backing it up with a court order, and I'll show you some examples later on. Understand this, that when you issue an order, they don't always obey it. Okay? So now you have to push it further. Now, how would you push it further? Well, probably a mandamus. You'd take it to a higher court, not higher than yours, but a higher court than their court. And you get the appellate court or the Supreme Court to order the judge of the Superior Court to toe the line. You see, look at it this way. If you had a company and you hired an employee, and this employee came from an employment agency, he's a temporary employee in your company. So you then direct this employee to do things, but what happens if he refuses? You can't really fire him because he doesn't work for you. You have a contract with this employment agency to provide a body, and this body is not cooperating. So how would you handle that? Well, the proper way to handle it is you go back to the company you contracted with, and you tell that company, either make your employee straighten up or get me a new employee, or else the contract's over. Right? Isn't that the logical three choices you got? Well, that's what you're doing with the state. When you hire the judge into your court, the state is the employment agency. So rather than discipline the judge directly, which you could do with contempt of court proceedings, rather than do that, you could complain to the employment agency called the state, and the way you would do it is you would go to the appellate court. That's the higher authority from the judge's point of view. Okay? You say, straighten this guy out. And the procedure that you follow would be called mandamus, because you want them to mandate that he do something or not do something. Yes. So see, the mandamus is that's an order not to be disobeyed. That's why it's called mandamus.
Okay, I'm going.
Yep. I'm talking while you're going. So.
You're here to teach others, right?
Yeah. Well, I found out recently that kicking what you were talking about, taking it up to the Attorney General's office, your order, when you're giving it to the court, this is what I did, and getting it up to Ashcroft's office, for example, or the nominee, and telling them, did you order this authorization or whatever, delegated authority, and put it to question. And you send them the whole package, registered mail.
Right.
That's under 28 Federal Code of Civil Procedure, 509, pages 509 to 519.
Pages or sections?
Pages.
Okay, that doesn't do us any good because pages change. The sections are constant.
Okay.
What sections is it?
No section. It was just the pages. Federal Rules of Civil Procedure.
You have to have a section in there somewhere, or a rule number if it's the actual rule.
Okay, if there was, I overlooked it, but it's.
All right, we'll have to look on that. Which year was it published, so we can know what to look in for that page?
Don't have a year. It's just.
Okay. Well, it leaves us kind of afloat here.
Okay.
All right, but here's the concept, so you can know to look for it. The idea is the federal government has these rules, whatever they made up. The state can prosecute under those rules. But if the prosecution rises to the level of a felony, the federal government has said, before you can enforce any of our federal rules that are on a felony level, you must get our permission first. Now, he's saying that's on page 509 of the...
519.
And through 519?
Correct.
Okay, so it's about 10 pages worth that it's in there. So you get some copy, whatever that copy is, of the Federal Rules of Civil Procedure. Look that up, because if you've got a felony charge against you that invokes federal law, the state has to get permission first, according to what he's saying.
That's correct.
But let me make a further suggestion. The feds are very, very much involved with state business. It used to be that the feds got their money from the states by going to popular taxation, by going to borrowing money from banks, paper money, fiat money. By doing that, they've been able to loosen up their dependency on the states. And in fact, they've turned it around. Now I think it's across the board. I forget what it is. 15% goes to the states. It's pre-allocated. I'm not sure of my number, but one way, one program or another, they make sure that each of the states get something like 15%. But whatever the percentage is, the states are now dependent on the federal government, which inverts the power flow. But here's the thing. That means they're getting federal funding, right? Whenever the state conducts a federal procedure, don't they get federal money to help cover the costs? And if they do, they must meet federal standards. So it might be that that rule that was just mentioned might just apply here. It doesn't apply to you, but it does apply to the state, and you may be able to hang the state on violation of that rule. So it's just a thought. Yes, sir.
Now, is this on?
Yes.
Okay. In doing a default judgment in the state, you don't execute the damages on through a mandamus, I imagine.
Well, the default judgments and stuff, that's a whole procedure that we're not
That's
getting
separate.
into. We're not getting into that today.
Okay.
But that is a process, yeah.
Okay.
But basically, in summary, just to give you a hint on it since it's brought up, is a default judgment means the other person didn't answer within the time required. So now you say, well, okay, you subject them to whatever your proposed action was. You subject them, and then you have to get a writ of execution, which you deliver to the sheriff, and the sheriff then goes out and enforces it. He has the guns. That's the theory. That's just a quick overview. That's not complete. There's a lot of detail in there that I left out, but that's the idea. All right. Going down further. Here are the preambles to the California constitutions. 1849 Constitution. We, the people of California, grateful to Almighty God for our freedom, in order to secure its blessings, do establish this Constitution. There's your relationship again. The people established it. Is there anything in the word established that means they gave up anything? Nothing. You're sovereign before, you're sovereign after. 1879, 30 years later, the citizens of the United States voted on the 1879 Constitution. So the 1879 Constitution was never accepted by Congress. And most states, from what I understand, have two constitutions. The real one, which was established them as a republic, and then the one that they're using to operate by, established by the U.S. citizens, and they just, by changing the educational system, they've bamboozled everybody to thinking that it's the real Constitution. But even it says, if you go along with the scam they've got going, even it says, we the people of the state of California, grateful to Almighty God for our freedom, in order to secure and perpetuate His blessings, do establish this Constitution. The people are still sovereign. You know, the Ayatollah Khomeini was interested in establishing some form of government for I guess, was it Iraq or Iran? Iran, right. And he eventually settled down. He chose a republic. Why? Well, it's very simple. The people of a republic are above the law of the government. They're not above the common law, but they're above the government law. Okay? So the people who are citizens are subject to the government law because they are citizens of the governmental entity. So a republic, in one sense, is the best form of government to have. In another sense, it's the absolute worst form of government. What makes the difference? The difference is the knowledge of the people. Because if you don't know you can be a people and you're absolutely convinced you're a citizen, then guess what? You'll be a citizen subject to it. But a Republican form of government is how the powers that be in the government can exempt themselves. They know they're exempt, but the citizens don't know. So they can run a very nice dictatorship, okay, well maybe a not so nice one, but they can run a dictatorship over the citizens only. Why the ones that are people, they know they're free. I remember listening to United Nations speeches one time. It was back in the 50s. I wish today I had a transcript of this. It was really beautiful. This man he was a representative of a small country that was being somehow attacked by another country. And he was talking about the freedom of the people. He's talking about the rights of the people. How, you know, we should live in peace. We should not have to be attacked by this. And he's talking about justice, right? And he got through the speech, and then all of a sudden he stopped. It was just like the brakes went on. He suddenly stopped, and there was a moment of silence. And then he said, he says, I'm not talking about the little people. And then he went on to say, and I can't remember the words he used, but in effect what he said was, they're just cannon fodder. Okay? Cannon fodder. You know, cannon fodder? You can stuff them in a cannon and use them for bullets or something. You know, but basically what he's saying is he realized that when he was going too far on this, and whoever he had to pay attention to for his salary might think that he is suddenly undermining their sovereignty, right? and somehow granting power to the people. So he immediately corrected himself. Like I said, I wish I had a transcript of that because it was so beautiful how he expressed it. And but that's what it is in a republic. In a republic, the people are free. Now, if everybody knows he's one of the people, then everybody's free. Now, you see, in a republic, whatever rules are created by vote or by legislature, they're advisory. In a democracy, they're mandatory. Isn't that a great difference? In a republic, the rules are advisory, with one exception. That exception is if 100% of society is against you, then it becomes mandatory. So that's the dividing line between mandamus and just advice. Advisory. Okay. So to deprive the people of their sovereignty, it is first necessary to get the people to agree to submit to the authority of the entity they have created. That is done by getting them to claim they're citizens of that entity. Okay? So 14th Amendment, if you're born or naturalized and subject, then you're a citizen. Otherwise, you must be a people.
Could you repeat that about advisory and mandatory?
Okay? Want to repeat about advisory and mandatory. In a democracy, whatever rules are passed, they're mandatory on all citizens, on everybody. Okay? Majority rule. In a republic, whatever the majority says, that's advisory on the minority. What a difference, huh? Okay. The particular meaning of the word citizen is frequently dependent on the context in which it is found, and the word must always be taken in the sense which best harmonizes with the subject matter in which it is used. So that's something you got to watch out for. Don't get locked into a single meaning on some of these technical words. Just exactly what is a citizen? Well, look at the text around it to figure it out. Okay? There is no concrete single meaning to these words. So, what is a person? Sometimes some people say, gee, if you say you're a person, you're admitting you're a citizen. Not true. Because what's the definition of a court? A court is the person and suit of the sovereign. So there you have the word person being used in a sovereign sense.
Can you repeat that? It's hard to hear you.
Oh. Yeah. Well, do you want it on or off?
Off.
Okay, well then somebody go chase down the management and see if they can turn it off. We have to delegate that job. Okay. So, okay, you wanted, what was it you wanted repeated now?
Very last thing you said.
A court
Which was?
is a sovereign. A court is a sovereign.
Is that what I said? The last thing? Sovereignty? Well, it's a court is the person and the suit of the sovereign. So the word person, in that sense, is a sovereign sense. A person is sovereign. So you have to look at the context in which it's used. On the website, there's an article about how the Supreme Court has used dictionaries. It's a great article. Yeah, it blocks out the noise. Okay. You see, you got to remember that there's a common law maxim which says that substance overcomes form, or form is less than substance. Okay? So you got to understand that I have a thought in my head, and my problem is to communicate that thought to you. The thought is the substance. The means of communicating it are called words. And the words are a mere form. It's my attempt, my choice of words is my attempt to transfer that thought over to you. So when the Supreme Court looks at a word, if there's some disagreement on the meaning of the word, the dictionary doesn't really play a solid part in the decision. The Supreme Court will go look at the meaning, the usage, the context in which it's used, and based on that, it will come up with its conclusions, whatever it is. So the court does not just blindly take a dictionary and say, oh, this is what it means, therefore the law applies like this. It looks to a lot of things. It looks at legislative intent when the law was first made. It looks at the intent of the parties if there's a contract dispute. It looks at a lot of things because it's looking for the substance. The word is a mere form representing the real whatever it is you're talking about. Okay? So when you read your words, don't just blindly assume that all these technical words have single meanings. Now, this actually leads into which came first, the chicken or the egg problem. You know, you have to have an education in English in order to understand the law, and you have to understand the law in order to understand how to build the English language. Okay? So there's at some point you have to say, well, okay, there's a common understanding, and we use these forms, and we accept these forms until somebody disagrees. Then we have to hash out what it means. Okay, here's one that I really like. The very meaning of sovereignty is that the decree of the sovereign makes law. Okay? If you can't make law, then you're not sovereign. If you can't run your own house, you're not sovereign. Okay? That was American Banana Company versus United Fruit Company. But that is what sovereignty is, the very meaning of sovereignty. The decree of the sovereign makes law. So what I say in my lawsuits, the law of the case is decreed as follows. I have yet to have anybody challenge that. Isn't that interesting? You know, they read over that, and then they go down to my list of laws, and they come in with their own laws. But when they come in their own laws, they don't decree it. What they do is they cite the codes. Well, that's not law. By the way, why are the codes called codes?
Because
they're coded.
They're not law. Why are the statutes called statutes? They're not law either. Sometimes they refer to the law code, or sometimes they refer to the statutory law, help confuse you. But the fact of the matter is they're not law. What is law? Law, in the absence of any clarification, law means common law. Now, if you see it called statutory law, you know they're not talking about common law.
Where can we research that?
Well, I guess a good place to start would get a on the disk that you'll get, and on the website you can link to the congressional copy. You can look at the book called The Constitution of the United States of America, Analysis and Interpretation. Now that book is about 2,700 pages, and if you go to that specific section of where it talks about the judicial branch, and where it says the judicial power of the United States is something to the effect available to all cases in law and equity arising under the Constitution. And you might look up there in their explanation of what in law means. That's probably where you'd find it. That would be my first research step. I haven't done that, but that's my instincts, okay? But you have an actual case. You might even go look up that case. What the very meaning of sovereignty is that the decree of the sovereign makes law. Well, what's law? They might get into it there on that case, since it's a landmark case. Okay, a landmark case means a case that is especially important that everybody respects. Okay? Pardon?
It hasn't been overturned.
It hasn't been overturned. That's another thing. Speaking of overturning, okay, you can shepherdize your case. Now, Mr. Shepard spent a good portion of his lifetime analyzing cases and deciding which cases overrided which cases. Well, eventually that grew to a big effort, and now they have a set of books that are regularly published. And what you can do is you can look up a specific case and find out if there are any other cases that have overridden that case. Okay, that's called shepardizing. Now, what's interesting is this, is that if you are the sovereign and you decree the law, or if you decree that this case is your law, then shepardizing means nothing. Okay? Who's boss again? Who's the tribunal? Who's making judgment? Shepardizing doesn't mean a thing. Okay? Shepardizing. Now, I might shepherdize a case sometime if I have some doubt as to it. But see, my cases tend to be very fundamental. There is a maxim in common law that says that the law does not entertain trifles. Okay? In other words, for example, of a trifle would be, let's say that you stepped on somebody's lawn and then you got off the lawn, and now the owner of the lawn is going to sue you for breaking a blade of grass. That would be a trifle. Now, the reason I picked that example is because that's exactly what I read a Supreme Court justice say one time. Okay? So, that's, small points we're not going to bother with. You're not going to sue somebody for a dime. All right? So, we don't bother with trifles. Okay, small points. Don't worry about it. But if you got something major, my lawsuits all deal with very basic, clear stuff. You understand when somebody was wronged. A person was arrested for what? Who got hurt? Nobody. Who cares? That I deal with fundamental stuff. I don't mess with trifles either. There are some people who absolutely, every little thing is a violation to them. Well, those people are going to have a hard life. But you have to, at some point, you have to acknowledge that some problems you just don't bother with. Not worth it. Reservation of sovereignty. We went into that. Okay, your sovereignty cannot be contracted away from you. We went through that, so I don't think we have to cover Marion versus Jicarilla Apache tribe. Okay. The United States and the state of California are two separate sovereignties, each dominant within its own sphere. Okay? Separate sets of rules. And then they describe, here's a county as a person in a legal sense. Okay? A person is such not because he is human, but because rights and duties are ascribed to him. Okay? You are only a person if there are rights and duties assigned to you. Now, I want you to understand something. This word right, there's a word that gets abused a lot. Because if I'm tribunal, a right means something like a natural right. God-given, cannot be denied. There's no authority that can take that right away from me. But if a right is granted by a government, that's actually a privilege. Okay? So I would reread this sentence to say a person is such not because he's human, but because privileges and duties are ascribed to him. He's given a privilege and he owes duties back. Okay? Okay. So that to be a person, by that definition, is to be a citizen, basically. And the terms citizen and citizenship are distinguishable from resident or inhabitant. Okay? And from domicile. Okay, I just made it larger, that's why it went off screen. Okay? Right at the top. Yeah. Government, Republican government. Well, that's, here it is. Government, Republican, specifically Republican government, one in which the powers of sovereignty are vested in the people and are exercised by the people, either directly or through their representatives chosen by the people, to whom those powers are specially delegated. And there are the cases that support it. Okay? So you want to make sure you're in a republic. All right? And if you're in a republic, then these other definitions fall in place. Can I move to a different page now? Yeah. Okay. All right. Then we have the democracy defined, and that's it for that page. Okay. Okay. What was what? Yeah, that was under sovereignty, I think. Or is it republic versus democracy? No, we weren't in that one. No. I don't think so. No, this is something else. Okay? I think we were in sovereignty when we found that. Anyhow, republic versus democracy. Do you know the difference? Well, you do now, I guess. Okay? Let's look at the California admission to the Union. And there's probably a similar one for your state. Okay? Whereas the people of California have presented a constitution and asked admission into the Union, which constitution was submitted to Congress by the President of the United States by message date February 13th, 1850, and which on due examination is found to be Republican in its form of government, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the state of California shall be one and is hereby declared to be one of the United States of America, and admitted into the Union on an equal footing with the original states in all respects whatsoever, or whatever. And it be further enacted that until the representatives in Congress shall be apportioned and so on, okay, gets into other stuff. But you see, it's a legal concept. The Constitution guarantees to each state a Republican form of government. That's the federal Constitution. And before we could join in, they examined our Constitution to see if it really was Republican. Congress made a determination that it is Republican, and so they said, okay, you can join the club. But I remember reading somewhere that in 1879, they voted on this other Constitution. And that other Constitution, from what I've been told, I haven't really analyzed it or checked it out, but my understanding is that the second Constitution had never been approved by Congress. If you
Federal Congress, is that what you're talking about?
Exactly. The only Congress. Okay, so that is the admission. Okay. Now let's kind of cover a court of record here, briefly. What is a court of record? Well, I guess I can't show that in full size. All right. 5 requirements to a court of record. Keeps a record of the proceedings. That's number 1. Number 4, power to fine or imprison for contempt. Okay? Provision number 1 and provision number 4 Those two provisions you will find listed in Black's Law Dictionary, 5th edition. Okay? They don't list the other requirements. Now, provision number 5 generally has a seal. That means some courts might have a seal, some don't have a seal. One time, I saw the clerk stamp a seal on a paper in the United States District Court. Okay, the court seal of the United States District Court. You know what it was? It was a rubber stamp, and she stamped it, and when she removed the stamp, it left the ink, with ink, it left the word seal. That was their seal. I guess they were too poor to afford, you know, the kind that impresses the paper and so forth, because that cost $30 or so, $40. But you see, a court does not have to have a seal, but it may have a seal. Now, I have a seal, okay? When I file my court papers, anytime I issue an order, I have a seal, sovereign seal. It says seal. It has my name on it, has my date of birth, okay, the date that I was born. It has some words around it. It says wisdom, strength, beauty, you know, that kind of thing, whatever. But the point is, it's my seal. That's what counts. It can be anything you want. It can be any design, but it should have somewhere on it the word seal, okay? That, because some people look at a seal, they don't know it's a seal until you tell them. So you put the word seal on there. I think all corporate seals are required to have the word seal. And, you know, you always see that word somewhere, like the Great Seal of the United States or the Great Seal of California. It has the word seal in there. Otherwise, I guess it's not a seal. But in any case, the fifth requirement is optional. But requirements 2 and 3 are mandatory. The tribunal is independent of the magistrate, and it's proceeding according to the common law. When you got those two, that's a killer requirement, believe me. Okay, and I think we're at the end of our recording on this CD or something. Yeah. So we're going to take a short break while he changes CD and gets it set up. Let's make it a real 5-minute break, okay?